Start your know. All right. Who's this for? Mark? Okay. He is coming.
I'm off mute. What's that? Those are for Facebook Live. I didn't make any notes about the equipment, so I'm speaking from my heart. Good morning.
Good morning. Morning.
That is not a questionable package.
Oh, yeah.
That is,
It's not ticking?
it's not ticking,
All
no.
right.
Those are masks for you,
Okay,
sir.
thank you very much. Good morning.
Morning, how are you?
Good, how are you?
Good.
Robin, how are you?
Just trying to get some good clarification on it.
Oh, I've always wondered if we're ever gonna go back to
Okay.
shipping.
Yeah, no, what I hate is I'll get caught in between. It'll be like this, they might do the handshake or the other
Or like
one.
that.
It's like, I don't know which one we're doing today. Oh, good morning.
Good morning.
You're doing air bump.
Air high five, or there you go, you couldn't even get the air one right. Screw that up.
Wait.
Did you guys, see Mark did send a document last night? Yeah, okay. Linda has some hard copies.
Yeah.
Oh, Ron.
Hey, Jeff.
How are you?
Good.
Hey, how are you? Happy New Year. Tony, Happy New Year.
Same to you, Jeff.
Anybody mind that one too?
Talk with this
So
thing.
you
on.
will talk
No.
about compensation. Trying to cut the hours down.
Yeah, I mean, well,
Oh, you're
I
welcome.
wasn't even.
I can-
Okay, you're not gonna do anything?
No, it's just very important.
Yeah, no, that's fine. And because we'll talk after the meeting. Dave and I will be like a committee too. to work through
Yeah,
the show.
no, I agree.
So I don't know if you want to executive session before we
Yeah, I think
do the
that-
agenda.
that's always good.
Well, I know Joe wants to get into executive session at some
Right,
point.
so I think.
Well, we gotta do a protest, right?
Yeah, we gotta-
Oh, yeah. I mean, I'm talking at the end.
Oh, yeah.
Yeah.
Yes, it is.
Must be in.
Is Ina Joe on? Ina Joe, can you hear us?
I can. I have unmuted myself, so good morning, everyone.
Good
morning.
Just
Just
make
Mark's
sure
gonna
my
try to come
speakers are on,
here.
and is
I
Steve
think
on?
Wilson's gonna try to come here.
Is Steve on, our court reporter?
Yes, I am.
Okay, terrific. Let's start with the
morning.
Pledge of Allegiance. Good morning. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, let me just get set up here. I will note that all board members are present. Ms. Ina Joe Davis Chappelle is present via video conference, which is permitted under law. As the minutes reflect, everybody's here.
And just so you know, just got a message from Prosecutor Musson, he's just about here.
Okay. I will move to approve the minutes from the December 21st, 2020 board meeting, if there's a second.
Second.
Thank you. And any question or comment concerning those minutes? Hearing none, all those in favor signify by saying aye.
Aye.
Motion passes. Thank you. Motion passes unanimously. I will move to acknowledge the Secretary of State's Directive 2020-25, which is the United States Election Assistance Commission Administration and Voting Survey, and their 2020 annual expense report, as well as acknowledge receipt of 2020-26 directive, which is the appointments to the Board of Elections in each county for 4 terms, commencing March 1st, 2021, in the board's 2021 reorganization. If there's a second?
Second.
Thank you, gentlemen, Mr. Frost and Mr. Wondolowski. Are there any questions or comments concerning that? Hearing none, all those in favor signify by saying aye.
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 Thank you, Ronnie Joe. Next, we have, I'm just looking through our agenda, see if there are any matters we can get through before the hearing, just not so we're keeping people waiting while we conduct our hearing. Let's see here.
That's an appointment to office, not your office.
Yes,
Number 5.
Yeah.
let me find, this isn't working too well. Do you have that paperwork, Tony, by chance?
What do you need,
No,
Agenda
it's-
item 5.
not the agenda?
No, the actual,
Agenda item 5.
Yeah, oh, yeah.
We got it right here. Thank you.
all right, I'll move, if you could have some of that just available when,
Yeah.
I can't scroll through my service too easily. I will move to acknowledge the death in office and appointment of elected officials. Unfortunately, the passing of Mr. Wingenfeld in Valley View Village Council, and then also the appointment of an elected office to replace Mr. Wingenfeld, Mr. Pikeback of Valley View Village Council. There's a second?
Second.
Thank you. Any questions or comments? Hearing none, all those in favor signify by saying aye.
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 I will move to approve the ballot. Thank you, Ms. Chappelle. I will move to approve the ballot order for the March 16th, 2020 Mayfield Village, a special election, if there's a second.
Second.
Any question or comment concerning that? Hearing none, all those in favor signify by saying aye.
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 I will move to approve the allocation. Thank you, Ms. Chappelle. I should wait a moment. I will move to approve the allocation of voting booths for the March 16th, 2020 Mayfield Village special election, which includes the allocation quantities are based on social distancing and room size per polling location. A total of 11 voting booths will be allocated plus 4 DS200s precinct scanners, and 1 ADA auto mark, voting unit, and 5 electronic poll books. If there's a second. Second. Are there any questions or comments? Hearing none, all those in favor signify by saying aye.
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 I will move to approve send a voter information guide for the March 16th, 2020 First Village of Mayfield special election. If there's a second.
Second.
Thank you. Any question or comment? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. Thank you, Ms. Chappelle. We have unanimous on all those motions. I am going to step up order here. Okay, Mark, right. I'm going to step out of order. Mr. Robin Roy, if you'd stand up. Come on up here, young man. We want to recognize one of our staff members, Robin Roy, on behalf of the board. Robin, thank you for being here and all you do. Robin was recently recognized for his abilities, talents, competencies as it relates to information technology, not only here in the Cuyahoga County Board of Elections, but assisting other board of elections through the Ohio Association of Election Officials, as well as other agencies throughout this county with his talents and skills. And because of that, he was recognized by New Century Cities, a publication that celebrates innovations and has recognized his essential work that Mr. Roy provides both this county boards of elections and the voters in the county. Whereas since 2004, Mr. Roy has been committed and valued member of the Cuyahoga County Board of Elections Information Systems Department. He heads up that department for us, and Mr. Roy continues to work tirelessly and in a bipartisan manner with election officials throughout the state of Ohio to administer fair, accurate, and transparent elections in service to all voters of Cuyahoga County. Whereas Mr. Roy has exemplified his dedication to strengthen election security, increase public confidence in elections by creating comprehensive, multi-phased security strategies for Cuyahoga County Board and to provide redundancy needed of a strong election infrastructure. And Robin, through his leadership, has earned our respect and gratitude because of years of outstanding service to our community and most importantly to the voters of Cuyahoga County. Now, therefore, be it resolved that the members of the Board of Elections join together with our staff in presenting you, Robin, with this resolution to acknowledge your leadership and service to the voters of Cuyahoga County as a Chief Information Officer. We really appreciate your efforts, and we're much better off to have you with our agency and appreciate the value and benefit you add to us. Congratulations.
Thank you.
Let me hold that up with
Yes.
Robin and I. You'll get this signed for you, Robin, in a moment, and have something to present. Thank you very much.
Wonderful.
Thanks.
We really do appreciate your willingness to just kind of delve into anything. I know Rob, when he was chairman of the Ohio, president of the Ohio Association of Election Officials, brought you into that organization. I know you assisted in developing their webpage, and you've made yourself available throughout the state to answer questions, provide assistance to other boards when they have information technology issues. So thank you so much, Rob.
Now I have to chime in. I want to correct one thing. Robert was already very involved with OAEO even before I was president, and going back to when former Director McDonald was a trustee. And Robin Roy has been really integral to building up the communications of the OAEO and making it a strong organization that it is today. So thank you for your work here at the Cuyahoga County Board of Elections, but I can tell you the entire leadership of the OAEO thanks you as well.
Thank you. Okay, we're going to come on to the protest we have. We have a protest hearing for the Village of Woodmere recall election. A date has been set for that election. I believe it's February 23rd. Is that correct?
That's correct.
And prior to that, a protest has been filed on behalf of the certain council members of Woodmere protesting that recall. In present, we have a lot of paperwork that was submitted on both behalves. Mr. Patakos, is he present? Mr. Patakos?
Yes, sir. Patakos. Thank you.
Patakos. Thank you, Mr. Patakos. I want to make sure Patakos. So you're here, Mr. Patakos. And also, Mr. Butler, you represent the individuals protesting. Mr. Patakos, that would be President of Village Council, Jennifer Mitchell Early, Lisa Brockwell, Glenn Todd Miller, and Craig Wade. Is that correct, sir?
Mr. Chair, this is Kevin Butler. Nice to see you. I represent the circulators of the petitions that are under protest today.
Yes, sir.
Right, I'm talking, well, hold on, gentlemen, Mr. Patakos, you represent the members of council that have been asked to be recalled, is that correct?
Yes, sir. Thank you.
Okay,
That is
and one at a
correct.
time, and then I just read their names off. I just read their names off, was that correct?
Yes, sir.
Okay, great. Now to Mr. Butler, you represent the individuals that placed this matter on the ballot. And could you introduce yourself, Mr. Butler, and who you represent?
Thank you, Mr. Chair. I'm sorry for speaking out of turn. This is Kevin Butler with the firm McDonald Hopkins. I represent the circulators of the petitions that are under protest today. They are Trina Carrier, Allison Craig, Rachel Cab Efron, Gladys Melvin, and Tony Parker. I have with me today on the line to speak on the matter, Rachel Cab Efron from among those individuals.
Okay, let me just set a few ground rules, gentlemen, here. Everybody is going to get their chance to present their case to this board. I just ask you not to speak until you're recognized so everybody can be heard. There is a delay when I speak and when our members that are here present speak and hearing you. So I need to be patient to make sure I hear everything. We have hundreds of pages of documents submitted by both Mr. Patakos as well as Mr. Butler. I know our board members have been through those, may have questions relating to them. I also want to let you know our board members may interrupt you with questions that come up during this hearing. Additionally, we may be taking notes during the hearing. It isn't that we're not listening, but we're taking notes just to follow up on questions we may have. At this point, I'm going to start opening with Mr. Patakos because he has got the burden here at this hearing. And we have Mr. Musson here, who's our attorney. Mr. Musson, what is the standard of proof, simply the standard of proof for this hearing today for the protesters as it relates to their burden in this protest? If you could just share that with the board.
Thank you, Mr. Chairman. Yes, the protesters bear the burden of presenting clear and convincing evidence that their protest is supported.
Okay, so it's a clear and convincing evidence standard, which is lower than beyond a reasonable doubt, but greater than likely or not a preponderance of the evidence, correct? Okay, terrific. Mr. Patakos, why don't you start off, if you have an opening statement, if you want to proffer any documents at this time, just let us know what those documents are because we have them. And then Mr. Butler, I'll hear from you in response to your opening, and then we'll come back to Mr. Patakos if there's any additional evidence you want to submit or if you want to just kind of proffer the documents you have and provide argument to the board, okay? Mr. Patakos, the floor is yours, sir.
Thank you. I really appreciate the introduction and the ground rules, and especially clarifying that the standard of review here is clear and convincing evidence, because I think it's very important to recognize at the outset that I am not here to argue, my clients are not here to argue, and this board is not here to adjudicate whether the circulators of the petition have engaged in a criminal act. We are not here to call these circulators criminals. We appreciate that they are participating in the democratic process. These are not criminal proceedings. And I say this and I emphasize this up front because the submission by the circulators repeatedly emphasizes this beyond a reasonable doubt standard and asking the question of whether his clients are criminally liable. And that is just simply not what is at issue here. The issue is whether these petitions that were circulated are valid under Ohio law and whether this issue can validly, lawfully be put on the ballot. And as we have submitted on the papers, it is not. And I would like to take, I think this is going to take me about 10 or 15 minutes to make an opening statement addressing the main contentions that the circulators made in their written submission that was just submitted on Monday at the end of the day. So I want to address some of those issues up front, but I do believe largely, as the commissioner said, that this can be decided on the paperwork that was submitted. My clients are here ready to answer questions. I'm here ready to answer questions, but I think largely the facts that matter here are really either not in dispute or they are not really subject to reasonable dispute. So this is really what is before the board here is a legal determination and a determination of how the facts apply to the law. And I will explain why. So thank you. Can everybody hear me
Mr.
okay?
Patako? Yes, we can. And I'm glad, I think you're finished with your opening statement. What I heard from you is, you know, after we hear from Mr. Butler, we'll come back to you and you can start presenting argument on your client's behalf to this board, okay?
Okay, well, I that was just the preview to my opening argument, but the opening statement, but that's okay. I mean, if you want to give him the floor now and I can resume, it doesn't matter to me.
Yeah, I think you gave us a nice opening statement. We're going to go hear Mr. Butler. Then we're going to come back to you and you can present argument and witnesses, et cetera, okay?
Okay.
All right, and then we're going to come back to Mr. Butler to present his side of the case too, okay? Great.
Okay.
Mr. Butler, you have the floor, sir.
Thank you, Mr. Chair. The reason that the circulators mentioned the standard of proof as being beyond a reasonable doubt is because the protesters here identified as their only rationale for protest that the circulators violated a criminal statute which prohibits the circulators of petitions from making false statements concerning those petitions when they circulate the petitions. That would mean that by a clear and convincing standard, the Board of Elections today would have to find that the circulators violated a criminal statute. That is why we mentioned the burden of proof applicable to criminal violations. We're not asking you to find beyond a reasonable doubt that the circulators committed a crime, Mr. Chair. We are suggesting that the only ground here for the rejection of a petition under the state law, which we've argued isn't applicable anyway, the only ground is the violation of a criminal statute. And so you would have to go so far as to determine by clear and convincing evidence that that statute had been violated in the circulation of those petitions. And in order to do that, you'd have to go through the elements of the crime itself and make the determination, according to the standards of proof applicable to crimes, that the crime has occurred. So that's why we've argued that particular point in our written materials. But we primarily have argued that the charter controls here. The state law with respect to petition concerns and protests does not apply to this chartered provision. The charter, in fact, does not yield in any way to state law on these particular recall election issues. The charter controls. The clerk of the village council in this case has certified the sufficiency of these petitions under the terms of the charter, which does not defer in any way to state code. And as a result of that, these petitions are now sufficient. And all that's left to do is to certify the date of the election, certify the election itself. So that's going to be a preview of our argument today. And we welcome any questions that you may have as well.
Okay, very good. Thank you, Mr. Butler. You know, we have Mr. Musson here. Mr. Musson, I know you have provided us counsel, and you've read Mr. Patekos's protest. I know you've read the rebuttal from Mr. Butler. What is your position in regards to what authority we have or jurisdiction we as a board have to hear this matter?
Sure. Thank you, Mr. Chairman. I think the charter does provide the means for a recall. However, the charter also in Article 2 references the powers of the village are exercised in a manner as provided by the laws of Ohio, unless there's a contrary intent in the charter or the enactments of council. Here, there is no expressed intent one way or another with regard to the general law of Ohio concerning the board's powers to review protests concerning petitions and recall petitions in particular. The petitioners do point out two other sections that specifically reference the general law with regard to specific aspects of the charter. But in the recall section, it's silent as to whether or not the general law fills in the gaps and completes a comprehensive mechanism for carrying out a recall proceeding. So in my opinion, you need to harmonize the charter with the revised code. And the way to do that is the clerk determines sufficiency, which I understand from reading the charter is the number of votes, number of signers of the petition, whether it achieves threshold to get it placed on the ballot. The form or regularity or any of the other considerations that the board can consider under Title 35 are still fair game. It does not contradict or conflict with anything in the charter. Silence does not implicate conflict in this case.
Okay, so it's your position that the board has jurisdiction. While Mr. Butler may disagree with that, I would prefer just to move ahead. Mr. Butler, I'll provide you an opportunity to argue that when it gets to your turn here, to argue again jurisdictional if you'd like. But I just wanted to proceed acknowledging what your position is, sir, Mr. Butler, what our counsel tells us that we can hear the matter, and then of course you preserve the right to make argument when it's your turn. Okay, sir?
Thank you.
Mr. Butler?
Thank you.
And Mr. Patekos, I'm assuming you do not object to this board hearing this matter, is that correct?
No, sir, I do not. And, you know, I was up very late last night researching and reading up on the contentions that Mr. Butler made in the submission that he submitted on Monday. And my research certainly confirms Mr. Musson's position. And I have some clear citations to Ohio Supreme Court authority that I would like to provide in my argument, which I will get to at your request. So I certainly do not object. I agree with Mr. Musson. I agree with Mr. Musson entirely here.
Okay, I just wanted to get through that threshold issue at this point, providing Mr. Butler, reserves the right to continue his argument. Having said that, Mr. Patekos, why don't you begin with argument and present your case to this board?
Thank you. And as I said, I will continue to address this threshold question because I do think it is important and, and it does form the primary basis of the circulator's opposition to our protest. So as I think is clear, the matter before the board is really about two main questions. And the first question, as was just discussed, is do the Ohio Revised Code provisions at issue, and that is 3501-39 and 3599-14, apply to the Village of Woodmere? Or is the village somehow exempt from complying with these state statutes as the circulators have argued? The second question is, if these statutes do apply to Woodmere, which as Mr. Musson has concluded, and I agree and will continue to argue, they plainly do apply or we would not be here today. The next question is simply, do the recall petitions at issue contain demonstrably false statements of fact? Because if these petitions do contain demonstrably false statements of fact, the petitions cannot be accepted by this board under the Ohio Revised Code. So I believe that the matter before this board is very simple, despite the lengthy submission that the circulators have submitted. I believe that words have meaning. I believe that Ohio law is clear, and also just basic common sense is clear that elections are important, elections are serious matters, and when petitions are circulated and when statements are circulated on official election ballots, those statements have to be true. There cannot be materially false statements of fact on these petitions, and that's really all this is about. And I think this really comes down to three questions, three ultimate factual issues, which are, the circulators' petitions say that my clients didn't attend any public meetings about the master plan. My clients plainly did attend several public meetings about the master plan. This alone invalidates the petition. Their petitions say further that the Woodmere Code doesn't require a special permit to own poultry. In fact, as we have submitted and as the documents leave no room for doubt, the Woodmere Code plainly does require a special permit to own poultry in Woodmere. Again, this alone invalidates the petition. Finally, their petitions say that my clients voted against reestablishing the village website. My clients plainly never voted against reestablishing the village website. This alone invalidates the petition. So on any of these three bases, now we did submit a fourth issue about a sidewalk, and I believe that is similarly false, but the factual circumstances of that issue are more complicated, such that I don't even think we need to burden the board with that argument. So I've advised my clients to withdraw that particular argument. We can just focus on these three because they're simply much easier and can be dealt with much more efficiently by the board and by any court that if it becomes necessary for further litigation here. So we can just stay focused on these three basic issues, because as to these basic factual questions, the underlying facts are largely undisputed. The meetings that my clients attended are clear. What the Woodmere Code says is clear, and the votes that my clients made are clear and documented, which has been submitted to this board. So again, while my clients are here willing and ready to answer any questions that the board may have about the facts at issue, I believe this is really going to come down to the board's legal analysis. First, as to whether the statutes we cite apply, and then as to how the facts at issue apply to them, or how the law applies to those facts. So I would like to start by addressing petitioners or the circulator's argument that they are somehow immune from complying with the Ohio Revised Code, before then addressing the undisputed or undisputable facts establishing that the relevant code provisions have been violated. So first, the claim that the statutes at issue, 3599.14 and 3501.39, do not apply to the village. This argument is invalidated both by the plain language of the statute as well as clear Supreme Court of Ohio authority to the contrary. First, if you read the plain language of 3599.14, you will see that it applies to, quote, any petition presented to or filed with the Secretary of State, a Board of Elections, or any other public office for the purpose of submitting a question or issue to the electors at an election. 3501.39 expressly incorporates 3501.38, which contains the exact same language. So it's important to point out that while the circulators cite a smattering of case law in their submission, none of these cases addresses either one of these statutes. And there is not a single Ohio case supporting their proposition that home rule somehow invalidates this provision, or that the Woodmere Charter somehow conflicts with it. And here, I think Mr. Mussin's use of the word conflict is critical here, as I will explain. Contrary to the circulator's position, when you perform a basic Lexis search of the term home rule, you can search all Ohio cases for the term home rule. Combined with either one of these statutes, you will find only 5 cases in total, which are 3 of them are largely irrelevant to these issues. The terms are only mentioned in dicta, but 2 of them come out squarely against the petitioner's position here, the circulator's position here, I should say. The first and most salient of these cases is State ex rel Ebersole v. Delaware County Board of Elections. The citation for that case is 2014 Ohio 4077, and the especially relevant paragraphs are 46 through 48. In this case, the Supreme Court of Ohio expressly addressed 3501.39's provision that a Board of Elections may not accept a petition if it violates any requirement established by law. And it did so in the exact context at issue here. That is, the circulators in that case argued that these state law provisions were inapplicable to them because the Powell City Charter did not expressly incorporate those provisions. In a pure curiam opinion, the Supreme Court addressed this contention by stating, and I quote, "This argument misstates fundamental home rule principles. In matters of local self-government, if a portion of a municipal charter expressly conflicts with parallel state law, then the charter will prevail. But here, the Powell Charter is silent on the question of the board's power to conduct protests. Therefore, no conflict exists." It's the same situation here. The court then continued to state, "The issue is not as complicated as the parties make it appear. The duties of the board, as set out in state law, supplement the duties described in the charter." Again, I would submit similarly, the issue here is hardly as complicated as the circulators would want it to appear. The duties of the board here are clear. Now, the other relevant case that comes up when you search these statutes in the context of a home rule analysis is Spatafora v. Toledo City Council, and that is 1994, Ohio 473. In Spatafora, the court, same thing, the Supreme Court of Ohio analyzed an analogous statute, that is 351906, which states that a referendum or initiative petition may not be verified by a board of elections if it contains a statement that is false in any respect. In analyzing this statute, the court expressly noted that it did involve statewide referendum and initiative petitions, but the court held that it may also be applied to a municipal referendum petition. In doing so, the court found that on the face of the petition, there was a false statement. Thus, the court held City Council not only had the right to reject the ordinance placing the proposed charter amendment on the ballot, it had the duty to do so. And notably, the court said specifically, one of the requirements of this statute is that an initiative or referendum petition speak on its face the truth, which similarly is the case as to recall petitions under 3599-14. False statements on these petitions are simply not permitted. Thus, this board must reject the circulator's contention that it is somehow not the board's business when a petition circulator puts a demonstrably false statement of fact on an official election petition and then circulates that petition to voters to obtain their signatures for the recall of an official who the demonstrably false statement is against. Now, I'll move on to discuss the standard of review again.
Mr. Potatoes?
Yes, sir.
I want to, could you wind up the argument here just about, because I'm going to, about our jurisdiction, because I want to move to Mr. Butler and let him argue that. And then what I intend to do is make a motion for this board to consider after we hear argument from both sides. All right, because we got to get through this threshold issue first. So do you have additional argument in that regard? Or are you ready to wind that up?
I think I'm ready to wind up the argument on jurisdiction. I do want to make a brief point about the standard of review in response to Mr. Butler's argument on that, because while clear and convincing evidence is the standard with respect to a court's review, where if we were to go file for a writ of mandamus or a writ of prohibition against this board, depending on what it does today, the Supreme Court's standard of review would be clear and convincing evidence. But I believe the law is clear that an administrative hearing, in an administrative hearing like this, the standard of proof is a preponderance of the evidence. And the cases there are Cleveland Clinic Foundation v. Board of Zoning Appeals, and that is 2014 Ohio 4809. Where the board's decision simply needs to be supported by a preponderance of reliable, probative, and substantial evidence. I believe the clear and convincing standard does not come in until we get to the Supreme Court. I believe for now we are governed by administrative hearing standards. Another case on that that's very clear is City of Independence v. Office of the Cuyahoga County Executive, and that's 2014 Ohio 4650. The court weighs the evidence to determine whether a preponderance of reliable, probative, and substantial evidence supports the administrative decision. And if it does, the court may not substitute its judgment for that of the board. So I believe the clear and convincing standard applies once we go to the Supreme Court or the 8th District for extraordinary relief. But until we get there, we are talking about a preponderance of the evidence standard. And the last thing I will mention before turning it over to Mr. Butler is that there is a very recent Supreme Court of Ohio opinion, Buddenberg v. Weisdak, and that is 2020 Ohio 3832, where the court states that a statute that provides for civil liability against a person who violates a criminal statute, but does not say that liability is limited to someone who is found guilty of violating the statute, does not require an underlying criminal conviction to impose liability. So what we're dealing with here is actually a civil statute that imports standards from a criminal statute. So this is a civil case, it's a civil matter, and the standards that apply are those that relate to civil cases. Just because a standard from a criminal provision is imposed, it does not mean that we need to prove anything beyond a reasonable doubt. That said, in closing, I believe that we will and have proved beyond a reasonable doubt that these statements are false. So in another way, this is academic. And I think that an easy way for this board to avoid that issue, if it were inclined, is that it can simply look at this evidence and say that these are false statements of fact beyond a reasonable doubt based on the evidence that has been submitted. So if you just want to hear my argument on those issues, okay, thank you.
Mr. Butler, please present argument to the board strictly on the matter of jurisdiction since you brought it up.
Understood. Thank you, Mr. Chair. I don't believe Mr. Patakos addressed the two cases that we believe are most on point in the Supreme Court of Ohio on this particular issue. The first one is Finkbeiner versus Lucas County Board of Elections, which construed a recall petition effort in view of a charter provision and the revised code. And it determined that because the charter in that particular case, which was in another community, did expressly incorporate election law and deferred to state election law, the board was within its jurisdiction to ascertain whether state code applied to those recall petitions, and in fact determined that state code did apply to those recall petitions and invalidated the petitions because they clearly violated a provision of state code which requires an election falsification warning on those petitions. You'd have to contrast that with the other case we cited, which is the Blackman case out of the Supreme Court in 1983, which construed Springborough's village charter, home rule charter. In that case, Springborough's charter, like Woodmere's, did not expressly incorporate or point to or defer to in any way the state code provisions with respect to what has to be in a petition. And in that case, the Supreme Court decided, and we think correctly, that you only have to look to Springborough's charter in order to determine whether the petitions were sufficient. A similar argument was made in that case. The folks who were subject to recall argued that because there was not an election falsification warning on the petitions themselves, state code was clearly violated and therefore the petitions could be invalidated. The Supreme Court thought otherwise and said that we only have to look to Springborough's charter, which doesn't require an election falsification warning. And they confined the analysis to Springborough's charter in that case and ruled in favor of the petitioners, the circulators of those petitions. So that's why we think in this particular case, Mr. Chair and members of the board, Woodmere's charter alone applies. We don't believe that the board needs to look to state code at all in order to determine whether or not these particular petitions are sufficient, because the clerk, who has the ability to invalidate petitions or consider them deficient for a number of reasons, and with all due respect to Mr. Musson, whose counsel I'm sure is above reproach, I don't believe the charter limits the clerk's authority to deny petitions or render them insufficient to just the number of signatures. The clerk instead can determine whether petitions are sufficient for a number of reasons. All of the things that are required in the charter come under the clerk's scrutiny. And in this case, the clerk sent the matter to the village council, and the village council has in turn voted according to the terms of its charter to schedule a recall election. That is why we think Woodmere's charter alone applies and not the state code. On the other hand, Mr. Chair, we are fully prepared to discuss whether or not any state code provisions, including the one cited by Mr. Patakos, actually could stand in the way of the language used on these particular petition forms. And we don't believe, of course, that that's the case. But as for the threshold issue, that's our argument. We don't think Mr. Patakos has cited the appropriate case law. Those two cases are Finkbeiner and Blackman. They're in the brief that we've supplied. Thank you.
Thank you, Mr. Butler. Mr. Patekos, there's a threshold issue. I'm going to move that the Cuyahoga County Board of Elections does have jurisdiction to hear this protest today. My motion only relates to the jurisdictional issue, not to the merits of the protest at this point. If there's a second.
I'll second that.
Thank you, Mr. Wondolowski. Are there questions or comments from the board members concerning my motion? Okay.
Just a friendly amendment. I tried to kind of tease out some of the issues that are being raised, Mr. Chairman, and maybe this is for my own understanding of the motion, if you indulge me. That the threshold issue is whether or not the charter of Woodmere precludes the board from hearing a protest, any protest regarding a recall, regardless of the contents of the protest itself. So I just wanted to make sure that was what your motion, if I was understanding your motion correctly on that point.
Well, thank you. I think I could get a little more detail in it. Is that I will move that the village charter of Woodmere does not prohibit the Board of Elections to hear the matter at hand, today's protest. Is that getting a little more detailed?
Yes.
Okay. To my friendly amendment to the motion, is there a second? Second. Thank you, Mr. Wondolowski. Are there further questions from the board members on the motion pending? This is simply a motion on jurisdiction, not on the merits of the protest. All those in favor signify by saying aye.
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 Thank you, Ms. Chappelle. Okay, now we'll hear argument. Thank you, Mr. Patakos and Mr. Butler on that matter. I think we can move on now to the protest and the merits of the protest from Mr. Patakos. I want to remind you all, we have had hundreds of pages of documents that I know we've read through and exhibits that you want to proffer. We'll all make certain they're part of the record here today for both sides, for purposes of both sides, how you ever proceed determining, dependent on how we move.
Before we proceed, I wanted to clear up, if we can, one other issue that Mr. Patakos raised, and that is on the standard of evidence, standard proof. This is not an administrative hearing. This is a quasi-judicial proceeding. And as Mr. Musson has advised us, the standard in a Board of Elections protest hearing is clear and convincing evidence. I don't know that we need a motion on that, but I did want to perhaps clarify that is the standard under which we will be reviewing the matter today.
I would agree that is the standard. I'll be viewing the evidence here through, and I know Mr. Patakos argued, well, it's when you get to court, it's clear and convincing. Well, it's got to be clear and convincing here then too, if we're going to take it to court. We can't use a standard of proof that's a preponderance, and then the court says, well, it's got to be clear and convincing when we look at it. So I would agree with you, Mr. Frost. I don't think it's necessary to take a motion. If parties want to, argue that to the courts, then they're free to do that. But I thank you for clearing that up.
And part of it, for the record, I would want the court to know what standard we've used.
Absolutely, absolutely. Thank you. Thank you for clearing that up.
Mr. Chair, just a question,
Yes.
since Mr. Patakos did raise the issue about the standard of proof and cited to, I believe, appellate court cases. Are you aware, counsel, as to any Supreme Court cases that would support your position that the standard of proof is other than what we believe it to be, which is clear and convincing evidence?
I am glad to defer to the clear and convincing evidence standard, because I think that what the chairman just said makes a lot of sense. Look, I wasn't able to find a case specifically saying what the standard of review is one way or the other, because I think it's a tricky issue, because ultimately these cases are typically decided on extraordinary writs when it is necessary to take them to court. So I think it's very compelling what the commissioner just said, that if this has to go to court on a clear and convincing standard, then why wouldn't there just be a clear and convincing standard here? And you know, as they say, a fella has the right to change his mind. So I'm convinced, and I'm willing to accept that standard. So thank you.
Thank you.
Thank you, Mr. Patakos. Ms. Ina Jo Chappelle, any other questions?
No, thank you.
Okay, terrific. Mr. Patakos, we'll proceed with the merits of the protest, sir.
Did we vote on the motion on the jurisdictional issue?
Yes, we did.
Oh, okay, I'm sorry, I must have
Did we
missed it.
not? Yes.
Okay.
And it passed unanimously. Thank you. Mr. Patakos, the floor is yours, sir.
Yes, and here is where I frankly have less to say, because I believe that we said it all in our written submission. But there is one other point that I really want to emphasize here, and that is that Ohio law is very clear. This is case law across the country, from the U.S. Supreme Court on down, that trying to couch an effort to couch a statement in terms of opinion does not dispel the false implications of those statements, because a speaker may still imply knowledge of facts which lead to a conclusion that a false statement of fact is at issue. So while I agree with the circulator and Mr. Butler's submission that sure, opinions are wholly protected, they can state their opinions in these petitions, but statements that imply false assertions of fact, statements that clearly imply false assertions of fact, are actionable and are remediable. Remediable, what's the word I'm looking for here? This board can and must act on such statements. And some good case law on this is East Canton Education Association v. McIntosh. That is 1997, Ohio App Lexus 3957. That's a 5th district case that cites other authority. There's an 8th district case, North Coast Cable versus Hanneman, and that is 98, Ohio App 3rd 434. Another 8th district case, Tri-County Concrete, which is 2000, Ohio App Lexus 4749. Again, it states that it has been held that statements are actionable false statements when they can be reasonably interpreted as stating an actual fact about the individual that is false. Now, as far as I can tell, this specific issue has never been adjudicated by any appellate court in Ohio with specifically relating to whether there is an opinion or a fact. I believe it was the Spadafora case that I discussed before, did discuss a clearly false statement of fact, but that didn't really get into any arguments about whether it was an opinion or not. I'm sorry, that was the Ebersole case that dealt with a clearly false statement of fact. This has never been addressed. This issue has never been addressed by an Ohio appellate court or the Supreme Court in the context of an election recall petition. Again, I think that's clear I think the reason why is clear for a couple of reasons. One, because these statutes are relatively new. The statutes that the board is analyzing today were enacted, I believe, in 2002. I can just check this. Yes, 2002 for the grounds for rejecting a petition, that's 350139, and 359914 was enacted in 97 and amended in 2006, whereas 350139 was amended also in 2006, again in 2010, and again in 2017. So again, relatively new statutes. Election law is a quickly developing and newly developing, dynamically developing area of law. And I would also say that these issues, I think, you don't really see very many recall petitions because they're difficult to put together. And when they are put together, people typically are careful in not including false statements on them or statements that could be interpreted as false statements. I think Woodmere, of course, presents sort of a unique situation because of the low population, the low number of signatures that is typically required for a petition to be validated in Woodmere. So I think that's why you don't see much case law on this issue. So those cases I cited are more in the defamation context, but the principle I think applies just as well. And I think that, again, what this comes down to is when the law says you can't have a false statement in connection with an election petition, I think there's clearly a good reason for that. And I think that the Supreme Court and the Ohio appellate courts will be very quick to construe statements couched as opinion that clearly imply false statements of fact as running afoul of these statutes. I think the issue is too important to read these statutes in any other way. So with that stated, again, I would say this comes down again to these simple factual questions that should be clear from the paperwork submitted by the parties. Now, to break it down briefly, if you look at my January 15th letter, bullet point 1, the petition clearly states that my clients, quote, did not attend any master planning public meetings. That is effectively stating that my clients did not attend any public meetings about the master plan. Now, they've tried to argue that, oh, well, we meant certain specific master planning meetings. Like there were multiple public meetings about the master plan, and the circulators are now arguing that their petition intended to refer to specific meetings about it. But the implication here is that my clients simply didn't care about any of the master planning public meetings. The words in the petition say did not attend any master planning public meetings, when the record clearly shows that my clients attended several such meetings, including the July 14th, 2020 Planning and Zoning Commission meeting, during which a presentation on the master plan was given, and which the circulators, Seth Young and David Efron, were present. And that is Exhibit 3 of our submission, where the minutes even quote that Lisa Brockwell spoke. Councilwoman Lisa Brockwell, who is subject to recall here, my client, stated that she spoke to residents on her street about the master plan. And Council President Jennifer Mitchell Early, also my client here today, stated at this meeting that the master plan was brought to the July 2020 council meeting. And there is further evidence that my clients attended other public meetings, at least 1, 2, 3, 4 other public meetings discussing the master plan. And that is the minutes for those meetings can be seen at Exhibit 4, Exhibit 5, Exhibit 6, and Exhibit 7 that simply make it a demonstrably false statement of fact that is included in this petition that states again that my clients did not attend any master planning public meetings. They simply did. There's no disputing it. It should be an open and shut issue. This alone invalidates the petition. Now, the second statement that we are taking issue with is, and the specific words used in the petition are that my clients, quote, acted improperly in requiring a new family to obtain a special permit for small farm animals, namely poultry. So what this effectively says is that the Woodmere Code doesn't require a special permit to own poultry. This is a yes or no question. It's a demonstrable statement of fact that is false. The Woodmere Code plainly requires a special permit to own chickens. That has been made clear both by the Woodmere Ordinance 50513, which is submitted as Exhibit 8, the minutes of the public hearing where Mr. Consolo, the Woodmere Law Director, read this ordinance into the record, and that is again Exhibit 9. No person shall maintain, keep, or stable farm animals, including chickens, without receiving a special permit from the village. And Exhibit 10, the minutes of council that again refers to this ordinance 50513. the circulators were present at all of these meetings. Now, I would say it doesn't really matter whether they were present or not, but I think that the fact that they were present only underscores the fact that these are just knowing and demonstrable false statements of fact. The suggestion, the implication, the statement that the Woodmere Code doesn't require a special permit to own chickens is false, and it is actionable by this board. It alone invalidates the petition. Finally, the third argument, that the third statement that we will take issue with is the statement in the petition, quote, that my clients, quote, voted against reestablishing the village website, when in fact there was never any such vote. And what's happening here is that the circulators have misrepresented a vote to suspend payment to a specific contractor who was deficient in performing under the contract, had effectively breached the contract. So the actual ordinance at issue, which is attached to our submission as Exhibit 11, is a vote to suspend payment to this contractor. It was simply not a vote against reestablishing the village website. The implication to the contrary is false. It is defamatory. It is simply a smear against my clients. All three of these statements are smears against my clients. If these circulators would have simply stated the facts accurately, they would have then been free to express their opinions about those facts. They chose not to do that. They chose instead to mislead the public and to include these false statements of fact in violation of Ohio law. I don't know how there could be any question about this. If the board has any questions for my clients that are specific, of course my clients would be glad to answer. But for now, I think what I would like to do to preserve the record is simply have my clients all affirm that they stand by the written submission that we made, and that, that they're just simply affirming my testimony here. I don't think we need to do direct examination of each one of my clients on these issues. And by my clients, by their participation here, can simply affirm that they are willing to stand on what we have submitted. I think that that's sufficient for our purposes, unless the board has any questions and subject to any cross-examination by Mr. Butler. Is that okay with the board?
That's fine, Mr.
I affirm.
Fine, Mr. Patakos.
Thank you.
If
So
that's what you'd like to do, why don't you? Go ahead.
So thank you. Let me just ask each of my clients on the record if they affirm. Jennifer Mitchell Early, do you affirm?
I affirm.
Lisa Brockwell.
Mr. Patakos, excuse me.
Yes.
Mr. Patakos, excuse me. Who do we have on the line right now?
Yes.
I have to swear them under oath, so I want to know who you're going to ask. Then I can swear them all at the same time.
Thank you, sir. Yes. So we have Woodmere Village Council President Jennifer Mitchell Early, as well as Woodmere Council members Lisa Brockwell, Glenda Todd Miller, and Craig Wade are all on the line here.
Okay. Thank you, Mr. Patakos. I would ask Ms. Jennifer Mitchell Early, Ms. Lisa Brockwell, Ms. Glenda Todd Miller, and Mr. Craig Wade to raise your right hand, please, and I will swear you in at this moment. Could you please do that? And I'm going to ask you, do you swear to tell the truth, the whole truth, and nothing but the truth at this quasi-judicial administrative hearing as you swear unto God?
I do.
I do.
I do.
I do.
Okay, I will acknowledge for the record that Ms. Jennifer Mitchell Harley, Ms. Brockwell, Ms. Miller, and Mr. Wade all stated in the affirmative that they will tell the truth and nothing but the truth. Now, having done that, Mr. Patakis, go ahead. They are your witnesses. Go on.
I would simply ask my clients to affirm, and I will state the question and then ask them all to affirm serially that the statements of fact contained in my letter dated January 15th, 2021 are true and accurate based on their firsthand knowledge, and that the exhibits attached to that letter are true and accurate copies of the documents as described in the letter. Jennifer, do you affirm?
I affirm.
Lisa, do you affirm?
I affirm.
Ms. Todd Miller, do you affirm?
I affirm.
Mr. Wade, do you affirm?
Let's slow up a little bit. Let's do the affirmations again, Mr. Patakos. Please state who you're asking the question to. Let them answer it, and then move on to the next person. I think we're getting a little delay in the video feed. So let's start again with Miss Jennifer Mitchell Early.
Thank you. Ms. Mitchell Early, I am asking if you will affirm that the statements contained in my January 15th, 2021 letter submitted to Linda Walker of the Cuyahoga County Board of Elections is true and accurate to the best of your knowledge, and that the exhibits attached to that document are true and accurate copies of the documents as described in that letter.
I affirm.
Very
Thank
good.
you. Okay, Ms. Brockwell, I will ask you the same question. Are the statements of fact contained in my January 15th, 2021 letter to the Cuyahoga County Board of Elections true and accurate to the best of your knowledge?
I affirm.
And are the exhibits to that document, are the exhibits to that January 15th, 2021 letter true and accurate copies of the documents as described in that letter?
I affirm.
And you have, in fact, reviewed that letter and the exhibits, correct?
Correct.
And Ms. Mitchell Early, you similarly have reviewed that document and exhibits, correct? Just to be clear.
Correct.
Thank you. And I will ask Ms. Todd Miller as well. Ms. Todd Miller, will you affirm that the statements of fact contained in my January 15th, 2021 letter are true and accurate to the best of your knowledge?
I affirm.
And based on your personal knowledge?
Yes.
And that the exhibits attached to that letter are true and accurate copies of the documents as described in that letter?
That is correct.
And you have in fact reviewed that letter and the attached exhibits, correct?
That is correct.
Thank you. And finally, Mr. Wade, I would ask you to also affirm that you have reviewed my January 15th, 2021 letter to the Cuyahoga County Board of Elections, as well as the attached exhibits.
I have. I affirm.
Thank you. And based on your personal knowledge, you can confirm that the facts stated in that letter are true and accurate, correct?
Correct.
And that the exhibits to that letter are true and accurate copies of the documents as described in that letter, correct?
Correct.
Thank you. With that, we would stand on the written submissions, subject to any cross-examination.
Mr. Patakos. Thank you, Mr. Patakos. I know on behalf of the board, appreciate you expediting this in regards to having your clients affirm the many documents you submitted on their behalf. And I know there may be some board members that have questions of you or maybe your clients, but procedurally, I will, in the light of that expediting the evidence as you presented it with these affirmations, and in light of that, I will offer up, Mr. Butler, if you have any questions of those witnesses specifically at this time, and then I'll open it up to board members if they have any questions. And then we'll move on to you, Mr. Butler, and hear your client's argument. So, Mr. Butler, do you have any questions of the four witnesses that Mr. Patakos had affirmed the evidence of?
Thank you. I believe Mr. Patakos identified Ms. Todd Miller, a councilwoman who had spoken with residents about the issue involving the master plan. And I did have a question for her on that.
Okay, proceed.
Thank you. Councilwoman, thank you for your attendance today. You had, I believe, indicated through Mr. Patakos that you had attended, or at least in the minutes of a meeting, Planning and Zoning Commission meeting, that you had attended meetings with residents on the street, a street you represent in the village. Is that accurate?
Yes, it was not an official meeting. I actually spoke with residents regarding, and you're speaking to which issue?
The master planning process.
Yes, of the master planning process. I did speak with several residents.
And those residents were members of the public?
Yes,
The Planning and Zoning Commission meeting is it's a meeting that is considered under the Revised Codes Open Meetings Act a public meeting. Is that your understanding of it as well?
yes,
Okay. Council meetings, village council meetings are considered public meetings under the Revised Codes Open Meetings Law as well?
yes.
What do you know of the public meetings that are called for under the master planning process produced by the Planning Commission for Cuyahoga County?
Can you be more specific to your question?
Were you aware that there were 3 meetings called by the Planning Commission called public meetings with respect to the master planning process?
I'm aware of the meetings that actually started in the year of 1999 on this master plan. So to say which specific 3 meetings, if you're speaking of the most current, was I aware of those meetings? I was aware of 2. And at that point, we were told that council was not required to attend.
You were aware?
And I'd have to go back to look at the details on the minutes of when that was stated.
Okay. You are aware then that that's what the Planning Commission called public meetings. You just said that, right?
Yes,
Okay. Is it fair to say that a meeting with members of the public that you have on the street, you'd view that as a public meeting?
these were conversations.
Okay, but you did indicate that you met with members of the public. Takis offered that as evidence that you participated in the master planning process by engaging with members of the public, right?
I did engage with the public.
Okay, but you didn't attend the 3 meetings, any of the 3 meetings, just for clarity, that were called by the Planning Commission, public meetings numbers 1, 2, and 3 in 2019, correct?
I attended, for your record, I attended the planning and zoning meeting that was through the commission giving a presentation.
Okay, but that wasn't one of the public meetings, the 3 public meetings that the Planning Commission called public meetings 1, 2, and 3, correct? The planning and zoning meeting?
I did not attend those. I viewed those on the website.
Okay, do you know whether any of your 3 colleagues on the call today attended any of those public meetings with you, or excuse me, any of those public meetings that I've identified as public meetings?
If I may take a moment to hopefully expedite this, there is no dispute that that none of my clients attended those 3 meetings. So we understand your position that there were these 3 specific meetings that you are saying are somehow the only public meetings where the master plan was discussed. We understand your position. None of my clients attended those meetings. So
Excuse me,
you can expedite this by stipulating to that. So the point, our point is that there were many public meetings where the master plan was discussed, and my clients attended many of those meetings as reflected by the documents attached and referenced in my submission to the board. So there is simply no dispute that you're referring to. So we can expedite by stipulating to that.
Mr. Patakos, thank you. Mr. Butler, Mr. Patakos is stipulating that his clients did not attend the 3 meetings that you are questioning about. Is that sufficient for your purposes in creating a record that they did not attend those 3 meetings?
Yes, yes, thank you. And I want to just be sure for the record that what we're talking about is not public meetings in general. We're talking about the public meetings that the Cuyahoga County Planning Commission, in the context of the master planning process, calls public meetings, the only ones that the Planning Commission calls public meetings, whereby officials, planning commissioners, planning commission staff, residents can gather and get information on the master planning process.
Can I just ask a question, just to be clear? I understand the line of questioning. So if the factual assertions that or this particular factual assertion that we're talking about that appeared in the document, they did not attend any master plan meetings. Are you making a distinction between the three meetings? I hear there's public meetings versus other meetings. Can somebody tell us how many master plan meetings there were? I mean, the allegation or the factual assertion in the documents that assertion doesn't seem to make a distinction between a public meeting, a meeting with residents, or any other kind of meeting. So I'm not sure where we're getting it may be a distinction without a difference. I don't know, but it seems like there's a distinction you're making about public meetings that doesn't appear in the language in the petition. They did not attend any master plan meeting. So can somebody enlighten us on that?
I would simply like to say that is exactly our
Oh, let me finish. Please wait. Please wait. I'd ask Ms. Davis Chappelle to direct her question to a specific individual, if you would. Mr. Patakos or Mr. Butler? Who is your question addressed to?
My question was being directed to Mr. Butler.
Sorry.
Okay, then we'll hear from you, Mr. Patakos. Then we have Mr. Wondolowski has a question. So Mr. Butler, please speak.
Thank you. Ms. Chappelle, there is no clear language distinction in this document that would suggest that the public meetings the council members did not attend were all public meetings. We're not suggesting that. In fact, it's clear in the petition that the council members voted against accepting the planning commission's master plan. It's right there. It was tabled. And it's in the second sentence of that particular paragraph within the petition. There has been no suggestion at all that the council members didn't discuss in public the planning commission's master planning process. These petitioners, these 5 circulators of these petitions, and the better than quarter of voters from the last general municipal election decided that they agreed with that statement, that they didn't attend the 3 planning commission public meetings on the subject. Our materials reflect that the planning commission, in fact, identified those as the public meetings. And so we're not suggesting in any way that the council members didn't attend a single Open Meetings Act public meeting on the subject. In fact, the second sentence makes that clear. We're not arguing that the master planning process wasn't discussed at any public meeting. We are arguing that the statement is true that they didn't attend the 3 public meetings called for by the planning commission. Whether that could have been more artfully worded is one thing. Whether it's a misstatement or a statement of untruth is entirely another. And it's clear from the context that those 4 council members indeed did attend a council meeting, at least on the subject. They did attend a public meeting because they tabled a vote on accepting the commission's master planning draft anyway. So.
Thank you, Mr. Butler.
You're welcome.
Thank you, Mr. Butler. I want to hear from Mr. Wondolowski, and then we'll hear from you, Mr. Patakis. Mr. Wondolowski.
Mr. Butler, I understand your statement and what you're trying to articulate to us, but this sentence clearly says any master planning public meetings. It's not specific to the 3 meetings that you have indicated. And it goes on to say, nor, and this is the recall petition of Craig B. Wade, goes on to state that nor educate himself on the project. I'm speaking for myself. I'm not looking at this thing from a legalese standpoint. I'm very practical in my approach to these things. That, to me, appears to be a false statement. In the statement itself appears to be false. It's not about artfully writing something. It's about accurately articulating something. And this is not accurately articulated. It has little or nothing to do with artfully written. So I have an issue with this first sentence because it's not, from everything I've heard today, it is not accurate. Thank you.
Okay. Thank you, Mr. Wondolowski. I'm going to stay focused. I mean, that's a statement Mr. Wondolowski's made, and Mr. Butler, you'll get a chance to respond to that, so make a note of it. Mr. Patakos, this is, it's your case in chief at this point. You've got evidence into the record. You've sworn in some witnesses. They've been cross-examined by Mr. Butler. You've agreed to stipulate to certain facts to expedite this process. Ms. Davis Chappelle asked a question to Mr. Butler. He answered it. Do you want to have anything to add to the question Ms. Davis Chappelle had asked of Mr. Butler about the meeting, sir?
I would, and I would like to simply echo first what Mr. Wondolowski said. I think his practical approach is one that is actually explicitly recognized in the case law that I cited about false statements of fact that are attempted to be couched as statements of opinion. I mean, he can talk, Mr. Butler can talk about these 3 specific master planning meetings, but that's simply not what this petition says. The petition says they did not attend any master planning public meetings. They attended numerous master planning public meetings. And here, the fact that they go on to say that my clients did not educate themselves on the project. Now, we're not taking issue with that specific statement for the sole reason that you could say that whether someone was educated on a subject is an opinion. But when you make that statement in the context of also stating that they did not attend any master planning public meetings, it is clear that that statement only amplifies the clear false accusation that they did not attend any master planning public meetings. So in this case, that so-called opinion that they did not educate themselves only serves to underscore the false and misleading nature of this statement that they did not attend any master planning public meetings. They did not specifically identify what public meetings. It would have been the easiest thing in the world for them to do so. It's very easy for Mr. Butler to explain exactly what he wishes that this petition said now, but it simply does not say that. It is here to paint. They have falsely misrepresented my clients as completely derelict in their duties to obtain public input on this master plan. It's simply a false and verifiably false statement of fact. This petition doesn't say all of this additional information that Mr. Butler is now, I guess, wishing that it did. So I will just leave it at that.
Thank you.
I think Mr. Wondolowski is
Thank
right.
you. Okay, let's continue to move on now. I think I've kind of summarized where we're at this process. Mr. Butler, do you have any other questions on cross-examination? Once you conclude with that, I'll give Mr. Patakos, and I'm going to start timing this now, gentlemen, so many minutes to do any redirect if he wants to, and then we'll move to the petitioner's case in chief, okay? So do you have any other further questions on cross-examination, Mr. Butler?
Mr. Chair, I'm sorry to ask to interrupt that line. May I respond briefly to Mr. Wondolowski's concerns?
You can do that in your case in chief, okay? I want to keep this. He's told you how he felt concerning your petition. I want to save that argument, and I think I know you'll make it when you present your case in chief, okay? Because we're just going to get out of order here. So save the argument. You're going to get a chance to argue that specifically, okay?
All right, understood.
I want to do your cross-examination. I want to keep this procedurally correct.
Thank you. Look, I'm going to reserve the opportunity to, I'm going to expedite the matter by getting to our case in chief. I'm going to call a witness who can testify as to these particular issues. But I would like to say this. Let me ask this question of the councilwoman whom I was just questioning. Councilwoman Todd Miller, do you have a recollection of at a public meeting voting to table discussion on the master plan draft? I'm sorry, I believe you're muted, ma'am.
Repeat your question to me, please, sir.
Do you have a recollection of voting at a public meeting to table discussion on the master planning document?
I do have recollection of tabling that particular item you're speaking to. You kind of convoluted for me when you speak to public meeting. Were you speaking of any public meeting or a finance meeting, a council meeting? What are you speaking to, sir, if I may ask?
Any public meeting. Do you remember doing that in any publicly noticed meeting of?
Yes, yes.
What meeting was that?
So we would do that in our council meeting.
All right, that's a village council meeting?
Yes,
And that meeting is called for a number of purposes, correct? To discuss a number of docket items?
yes. We
All right.
go through legislation.
Okay. Were there other docket items at the time when you voted to table that document, the master planning document? Were there other pieces?
As I stated, as I stated, when we have council meeting, we go through all of our legislation. So there would have been other items on the agenda.
Okay, that meeting would not have been called for the purposes of master planning only, correct?
Correct.
Thank you. That's all I've got. Thank you, Mr. Chair.
You're welcome. Thank you,
Okay,
sir.
Mr. Patakos, any brief questions on redirect of your witnesses?
Sir, I have no questions on redirect. I would ask that before Mr. Butler gets to his case in chief, if that is where he intends to proceed from here, that we take a short break for so that the parties can use the restroom and et cetera. We've been going for about 90 minutes. I personally need a restroom break.
All right, it is about, I think, 7 or 8 minutes to. Let's reconvene at 5 minutes after 11, where we'll start with Mr. Butler's case in chief, okay? 5 minutes after 11, I will be starting promptly.
Thank you.
That's okay. All right, while we're here, do board members want to break them too, for that purpose, instead of continuing with our agenda?
Yeah.
Okay, great. We'll take 5 after 11, we'll reconvene. Thank you.
We haven't heard a gavel in a while.
I've never heard a gavel. The reason is that it's the delay that just screws things up. Everybody's cross-talking, and it's natural. I get it. I do the same thing.
Yeah, they think it's dead air. But
So I've been doing enough of these in federal court where the judge says, do not talk until I acknowledge you, because there's a tendency to, anyway,
We should have those attorneys in here for this.
we're moving.
I know.
We're moving. So we staying healthy in the family, Mark?
Yeah,
Yeah.
my uncle fell off a ladder.
Oh, jeez.
Yeah, real bad. Went on his head. And he thought he caught
Is
it.
this your uncle or?
My mom's brother. Yeah. And he was in the ICU for a while. And he thought maybe he caught it in there because he came down with some symptoms, but he's tested negative so far. My cousin did get it. That uncle's son
Mhm.
did get it, but he's
okay.
25 years old. And yeah, he's coming out of it fine.
Yeah, it's something. Months ago, I mean, yeah, you just, you know, and you get the little sniffle or cough. You know, the kids are like,
Yeah.
get a test.
Yeah.
What's your rushing for, Robin? No. Oh, mood our conversation, okay. Okay, Linda, can you hear us? Linda Walker.
I
you
can.
hear us?
Yes, I
Okay,
can.
terrific. All right, and I'm wondering if Ina Jo is back online with us?
I am here.
Okay, great. Ina Jo's here. All board members are present. Mr. Batakos and Mr. Butler, are you present, gentlemen?
Yes.
We're both here.
Scott, Mr. Butler. Okay, terrific. I believe now you're done with your case in chief, Mr. Batakis. Is that correct? And you have, I will move to submit your exhibits and letter for the record, all exhibits that you've submitted to the board today. If there's a second.
Second.
Thank you, Mr. Rondolowski. Any question or comment? Any objection, Mr. Butler, from those exhibits that Mr. Batakis has submitted to the board?
No, Mr. Chair, no objection.
Okay, all in favor signify by saying aye.
Aye.
Thank you. Okay, we've got a record here, Mr. Batakis, on behalf of your clients. Now, Mr. Butler, it moves to your case in chief, sir. So proceed with argument, and if there are any witnesses or proffered exhibits. Thank you.
Thank you, Mr. Chair. I'd like to make some opening legal arguments at first. And one that I want to point out just as we begin things is that is in response to Mr. Pell's request for a Supreme Court cite on the standard of review. I do have a cite on that, State Ex Rel Richards versus Stark County Board of Elections. That is 2015 Ohio 3658, which requires a protester to prove by clear and convincing evidence that the protest should be sustained. So that is, in fact, and I would tend to agree with all the board members who have mentioned this point, and Mr. Musson, that is the standard of review today. I'll move on to the actual argument. The first argument I'd like to make is that anytime a board of elections relies on the statutes cited by the protesters here in order to ascertain whether to invalidate a petition, it does so under a clear statute or law that requires a certain thing to be either in that petition or out of that petition. So, for example, a falsification warning has got to be in most petitions provided for, all petitions provided for under state law. If this were not a home rule municipality, the revised code statute 70592 on recall requires that recall petitions contain a statement of 200 words or fewer as to the grounds for recall. Nothing more. That's the statement that's required. Doesn't talk about the accuracy of that statement. It just says there has to be grounds for recall in that particular statement. So too in the charter, there's an obligation for the circulators here to have included a statement of no more than 200 words as to the grounds for recall. And you'll find that in each of these petitions. There is no statute that has been construed by the courts. There's no law at all that's been construed by the courts to ensure that a board or a permit that would permit a board to entertain a discussion as to the accuracy of the statements submitted in the grounds for recall. I suspect that if there were, this board would have entertained other discussions of this nature in its history and other protests of this nature in its history. But it hasn't, except in the case of White versus Board of Elections way back in 1987. That's an 8th district case, which determined that the Board of Elections acted properly in scheduling an election, notwithstanding a protest made by incumbent council members in the Village of Orange as to the accuracy of the grounds for recall in the petitions that had been circulated calling for their recall. Mr. Patakis's argument that there are no appellate cases on point is just false. It's just false. With all due respect to Mr. Patakis, it's false. There are two important appellate cases on point, specifically with respect to the accuracy of language in a recall petition surrounding the grounds for recall. White is one of them. So that's that 1983 case. And in that case, the 8th District Court of Appeals held that the Orange Charter didn't require the recall committee, much like our circulators here, to allege or prove good cause or any specific ground for an office holder's removal. Consequently, the courts can't determine the significance of the charge or the sufficiency of any evidence to support those grounds. Those are, and I'm quoting now, those are political issues for the voters. That is to say, the grounds supporting recall are not meant for the courts to decide or the Board of Elections in the White case to decide. They're meant for the voters to decide. The voters who sign those petitions, they're the petitioners here, the circulators who came up with the language. They get to decide whether or not recall is appropriate. And in this particular case, the charter required a full 25% of those voting in the last municipal election to sign those petitions. They did. That means these petitioners are already halfway to recall, right? Because you need 50% plus one in order to get a successful recall. They're already halfway there. They believe that those statements are enough in order to convince themselves and their fellow citizens that recall here is appropriate. The White case stands for the proposition that it is not for a Board of Elections to decide whether or not statements constituting the grounds for recall are accurate, truthful, or otherwise. They just have to be there. They just have to be there. And there is no statute in the revised code at all that talks about the truth of what's in a statement supporting recall, the grounds for recall. There's nothing in the code that requires accuracy in that statement. Now, were the statements accurate in my client's view? Yes, they were. And I'll take testimony on that. I would ask you to take testimony on that, led by me later on. But for now, there is a separate threshold question, and that is whether the board could even act on this protest based on the statute, that criminal statute that prohibits a circulator from making a false statement concerning a petition, whether it could act under those circumstances, right? We don't believe that the case law supports the board here acting. The White case is very clearly on point. It says, in the allegations of fraud, corruption, abuse of discretion, clear disregard of statutes, decisions of a Board of Elections will not be disturbed, right? So your decision here is not likely to be disturbed on appeal anyway, but you cannot make the decision to intervene in what the White court holds is a purely political process. As the White court says one more time, those are political issues for the voters to decide. That case was mentioned in a later case, Langley versus Federolf, which discussed the same issue. Two sitting Newton Falls council members challenged the contents of a recall petition. They did so in court in that case rather than before the Board of Elections, but they mentioned the same statute that is applicable in this particular protest, that is cited in this particular protest, the criminal statute regarding making false statements concerning a petition as you circulate it. In Langley, those two council members claimed that the statements supporting their recall were false or inaccurate. The court in that case, which is the 11th district in 1993, decided that a person circulating a petition for recall is not required to allege even a specific ground, much less prove good cause for an office holder's removal. Same exact language as in White. In fact, it cites White in that particular moment. The court in Langley further says that the statements in support of recall don't actually appear on the ballot, and that is important. What's on the ballot is a simple question. Should the council member be recalled or not? That's it. Voters get to decide for themselves, number one, why they want to sign a petition calling for a council member's removal. That's number one. They may have another reason. They may have a different reason as to why to sign that petition, right? They may decide that they thought their council members did educate themselves on the master planning process, but didn't attend the 3 public meetings that were important for that education. They may decide for themselves that council did act inappropriately in denying the special permit for chicken raising in the village. They may decide that the council members, quote unquote, had a voting history that is not in the best interest of the village, which is specific language in this particular recall petition. They get to decide that as a political matter for themselves. It's not for this board to intervene and determine whether those voters were misled. They get to decide for themselves whether that petition should stand. It's different in other cases cited by Mr. Patakos. Mr. Patakos raises cases that have to do with referendum. I will do the same thing. In State XREL, Miller versus Diversified Holdings versus the Wood County Board of Elections. The Supreme Court in that case reviewed the accuracy of statements in a petition for referendum on a zoning measure. And the Supreme Court specifically cited a statute that prohibited inaccurate statements in that referendum petition. That statute is 519.12. It says that those petitions for referendums on zoning measures must contain a brief summary of the contents of the zoning amendment that's before the voters. And that under the applicable test, the summary must be accurate and unambiguous. Otherwise, the petition is invalid and the subject resolution will not be submitted for vote. There is no similar statute with respect to recall petitions. In fact, the only statute on point with respect to recall petitions merely says that the circulators must include a statement as the grounds for recall. That statement can say that the 4 council members think that the sky is brown when it's blue. It doesn't matter if it's accurate or not because there's no statute requiring complete accuracy. Statements of opinion are okay. There's nothing in the law that requires accuracy with respect to what's in a recall petition. Once again, I am not making the argument that what's in those recall petitions is inaccurate. I am merely saying that the board, under the relevant authority of the law of Ohio, cannot add a requirement that the grounds for recall be accurate in every way. Otherwise, these boards, for the first time in Ohio's history, would be having these protest hearings in order to adjudge that question. The Langley Court made it very clear. It's staying out of the sufficiency of the language around the grounds for removal. The White Court, the 8th district, the only 8th district case on point, makes that clear as well. It's staying out of that political question, and it's leaving that political question for the voters to decide. I'm going to give you the cite to the Miller case that I cited, the Wood County case that I cited, because it wasn't in our written materials. That is 2009 Ohio 4980, State XREL Miller Diversified Holdings versus Wood County Board of Elections. And in that particular case, The petitions misstated, very clearly misstated the number of acres that would be subject to rezoning. That's a clear misstatement of fact. The Supreme Court found that that is a clear misstatement of fact and that it violated that specific township statute, 519.12, because it didn't contain an accurate description of the zoning measure subject to referendum. There is no such statute at play in this particular matter. The Langley Court specifically refers to 3599.14, and it says, this statute is a quasi-criminal one and it serves a different purpose than to invalidate a zoning petition. The very statute that's cited as the only grounds upon which the protesters here wish to invalidate these petitions, a court has already ruled is inapplicable to this protest because it's criminal in nature and it serves a different purpose. We've also contended in our brief that this statute by its plain terms doesn't go to the heart of what's in a recall petition. It goes to instead what a petition, what ends a petition is meant to serve. So in the case we cited from the Supreme Court with respect to that particular statute, that's Jameson versus Franklin County Board of Elections. In that case, the Supreme Court held that a candidate's circulation of petitions inadvertently misstating the term of the office that she sought was not enough to invalidate those petitions. That statement, she was circulating those petitions and saying, I'd like to be elected for a term beginning on this date. The petitions themselves had her being elected to a term beginning on a different date. The Supreme Court said that doesn't violate the statute, but the statute itself has to do with statements made concerning a petition, not statements made within a petition. And I don't mean to split hairs, but that is Supreme Court precedent. The circulators here weren't saying, if you sign our petition, you'll get a $2,000 refund check. The circulators here weren't saying, if you sign our petition, I'm going to be elected to Woodmere Village Council. The circulators here said, if you sign our petition, it's going to result in a recall election. That is the kind of statement that would fall under the scrutiny of 3599.14. So we don't think this statute gives you the authority to invalidate these petitions to begin with. The cases in Ohio are on point, and they would tend to agree with that. Now, to the extent that you still want to make a factual exploration into each of these allegations, I am willing to call my witness. But if you'd like to have a legal discussion on that particular point, before we do that and take up more of the board's time, I would be glad to do that as well. And I would defer, of course, Mr. Chair, to you.
Yeah, why don't you put your witnesses on, take fact? I don't know, most of my board members have questions about the cases you cite. Why don't you put your witnesses on?
Yeah, Mr. Chair, I do think we should proceed as you've outlined, but I did want to know, and I do think there was this threshold question that perhaps we could have determined early on. I have no problem moving forward with, with Mr. Butler's case in chief, since we allowed the hearing on the evidence on the particular questions to be given by Counsel Batacos. So I just think that there is a legal question that perhaps we could have decided before we entertain the actual discussion on the questions, but just wanted to make that comment. Happy to proceed as you've outlined, though.
Okay, we can address that. What's your, I mean, you raised the point now, Ms. David Chappelle, that there's a legal question that we have to make a determination on. I mean, you put that out there for the board now. Yeah.
I mean, I did entertain and had a question about the specific factual assertions that were contained in the petition based on the case in chief that was put forth by Mr. Patakos. But I do think, I think it was Mr. Patakos said there's not a lot of law on this issue. And part of the reason I think there's not a lot of law is because I am not completely persuaded yet, but I'm kind of persuaded that there's no law because it is beyond our authority at some sense to be considering the veracity of the statements. That, under White and Langley, that they're arguably, we are moving beyond what our authority is. I'm struggling because I think that we are not obligated to determine the significance of the charge or the evidence, as the 8th District said in that case. And so, to me, we're moving down a slippery slope, perhaps, if we are going to consider these statements and to start to flesh out whether the statements are opinion or fact, or whether they are truthful or inaccurate, whether they're inadvertently stated incorrectly. I think there maybe is a dearth of case law on the issue because it's not our role to be considering it at that level of detail that it is, in fact, for the voters to decide. So I do think that there's a threshold legal question perhaps we have to address. But given the fact that we kind of moved down this path, I think it's in your discretion to some extent. And if Mr. Butler feels or Mr. Patakos feels like we need to hear the counter evidence, then we should do that to have a complete record. I'm not saying we shouldn't do it. I see Mr. Patakos, but I'm just saying I think there is a threshold legal question here that we need to decide, or perhaps we should have considered it in more detail before we actually heard evidence on the specific factual allegations at issue. But since we've done that, I guess, I just would be curious as to others' thoughts on that.
If I may respond.
Mr. Wondolowski? Yeah, along the lines of what Board Member Chappelle just brought up, and I struggled with this entire case from the time we received word of it, and even more so since we received our full board packet yesterday. And it is probably the most complicated one I've sat in on. I struggle with the statements that certainly appear to be either inaccurate or lacking detail, at the very least. Certainly appears that there's an ordinance 505.13 that specifically states a special permit is needed from council to own farm animals, and that is very clear. So to make a statement that people acted improperly requiring a new family to obtain a special farm permit, it's in the words of Attorney Patakos, demonstrably false. However, that said, I think the threshold issue is one of great importance. And I think that our attorney, along with Attorney Butler, have demonstrated enough of case law here that would indicate that we do not have, despite false statements, we do not have standing to take this into consideration. And, I struggle with it because signing petitions, I never signed one without reading what the petition was about, despite what a circulator would explain to me. So I, in this case, may have signed a petition based on those statements that are not accurate, or I may not have signed the petition, but I would have read that. So I struggle with that, but at the same time, I think the threshold issue is clear, And I do not believe that we can move forward with this. And I think it does have to go to the electors, as the petition states. And I am going to, although I know that there's going to be further discussion on this, I am going to move to deny the protest based on that.
If I may
Based on my
respond.
Thank you, Mr. Ron. Great. Thank you, Mr. Ronalowski. What I would like to do is let both sides argue with us. And I appreciate your positions. And then we, as a board, can have these discussions after we've had all the evidence
I
and
understand.
submissions and hear the argument, then make a decision. I think it's being a little premature here to say, in the middle of Mr. Butler's, and without Mr. Patakis even having a chance to cross-examine his witnesses, to conclude that where we're at. I understand Ms. Chappelle has brought up an issue about a threshold issue that Mr. Butler's arguing under 3599-14A7, we're limited to looking if misrepresentations were made in the circulation of these petitions, not to the language in the petitions themselves. And Mr. Butler is going to put some witnesses on, and Mr. Patakis will cross-examine those witnesses and flesh out that issue. But I also believe under 3501-39, we as a board do have the right to look at this. It talks about the Secretary of State or a Board of Elections shall accept any petition described in section 3501, and I can't remember the exact site, of the revised code unless one of the following occurs. And we're kind of looking at one of the following occurs. A written protest against the petition or candidacy, any specific objections is filed and a hearing is held. And determination is made. And that's what's happened here at some level, I think. You have two conflicting positions. So I think we do have the authority. We need to go ahead and hear the evidence and then make a determination as to whether this protest is going to be upheld or not, based on these two sections. So that's where I'm at. I know there isn't a second. Does someone want to second Mr. Ronalowski's motion at this point? We can open up for discussion. I prefer to proceed with hearing Mr. Butler put his witnesses on now. He's made his argument, and then have Mr. Patakis cross-examine those witnesses, and then hearing both sides give us, and I'll probably give them 5 minutes to summarize their argument. So that's where I'm at. Is the board okay with that?
I'm happy to move forward and to have a complete record, and certainly to allow counsel to have full opportunity to cross-examine and for the whole process to unfold. I do think that there's, and I think one of the, I think it may have been Mr. Patakis in his opening said, we really do have legal issues to first and foremost decide, then get to the factual questions. But I understand they're inextricably intertwined here. So I'm happy to proceed, Mr. Chair, as you've outlined. Thank you.
Anyone else on the board have a comment?
I'm fine with proceeding. I understand Mr. Wanalowski's motion, but I think I'd like to hear the parties present. I'd like to hear
I'll withdraw
Mr. Butler
the motion, Mr. Chair.
Okay. Thank you. Now, Mr. Patakis, I see that you wanted to be heard. I think you've heard how I intend to proceed. I will give you an opportunity to provide cross-examination as to Mr. Butler, because I think Mr. Butler's wound up his argument, wants to put some evidence on by way of testimony that you'll be able to cross-examine, at which point then I'm going to provide both parties an opportunity for 5 minutes for closing argument. Mr. Patakis, does that seem reasonable to you, that approach?
That's fine, sir. I would just like to make one brief point, which is that the cases that he has cited, White and Langley, were decided before these statutes existed in their current form. That's the whole point. I said that in the opening argument. I thought that threshold issue had been decided by the board, but I just want to emphasize, and I'm fine to rest and wait to make the closing argument, but these two cases were decided in the 1980s and the early 1990s, when you can see when they do not address the current language of these statutes as they exist now. And the issue of whether petition.
Thank you. Mr. Patakis, this is best saved for closing argument. It really is. I mean, I understand your point. It's best. I want to procedurally just follow process here. Mr. Butler, it is back to your case in chief. I think you've made an argument and you are at this point going to put a witness on. Is that correct?
Correct, Mr. Chair. I'm going to ask you to swear in Rachel Cab Efron.
Okay, Ms. Efron, are you present?
I am.
Okay, if you raise your right hand, ma'am, and do you swear to tell the truth the whole truth and nothing but the truth as you shall swear unto God?
I do.
Okay, great. Your witness, Mr. Butler.
Thank you, Mr. Chair. Hello, Rachel.
Hello.
Rachel, can you tell me what you do for a living?
I am a certified elder law attorney. I have a private practice that I own in Beechwood, Ohio.
Where do you live?
I live in Woodmere, Ohio.
Okay. Are you one of the petition circulators in this particular matter?
I am.
All right. Have you attended Woodmere Council meetings and other public meetings under the Open Meetings Act of the village
I have.
in the past 2 years?
Yes, I have.
Okay.
Not all of them, but I have attended a fair amount.
Did you have a hand in drafting the language that's in each of the 4 recall petitions with respect to the grounds for recall?
I did. I did.
And was that language also contributed to by other members of the petition committee?
That's correct.
Okay. All right. Do you agree with the statement that the council members, quote, voting history is not in the best interest of the village?
I do.
Right. Do you think that that particular statement is a statement of fact or opinion?
Well, I'd certainly say it was an opinion of mine and other people on the committee, but I would say that's based on opinion.
Okay. I'm going to move to the third paragraph of that particular grounds for removal, because the second paragraph is no longer apparently at issue. With respect to the voting against reestablishing the village website, can you explain why you arrived at that particular language?
Sure. On or about March. Well, first of all, if you look at our website, even today, it says at the top of it that it has been defunct or, not been updated, and it is not being maintained since April 30th, 2020. So they had voted against Stephanie Gandy. I don't know who that person is, but they voted against her managing the website any further. And so it became defunct. So they defunded it. And that was essentially the same as, what we said in the petition, that we have no website for the village. And so that was way back in April of 2020. Interestingly, they couldn't have a planning and zoning meeting yesterday because they couldn't put the notice. There's a required 3-place notice. And so having no website during the COVID pandemic to share information was really critical for our seniors, for our folks in the village. We have a lot of people that are on the web. And so they still don't have, I don't know all the details of it, but they still don't have anyone that's managing the website. They don't put the minutes up. They don't put the notices up. They had to have the mayor do it the last meeting so that they could have their January organizational meeting. So that's what we're dealing with. So we don't have a website. So I don't know exactly how it got that way, but they defunded it. They deactivated it by defunding it. So that's our issue with that.
On the website issue itself, are you aware of any later votes other than early in 2020 that also disapproved of a contract for a web designer?
Well, so in January, that was the only meeting that they had that was I don't know if it was the only meeting properly noticed. I can't say that. But in January, they had the opportunity to reinstate Stephanie Gandy's contract. I believe at this point, what I understand is that Miss Gandy doesn't want to do it, but we still don't have anyone in the village. They're talking about having some neighbor do it. I don't really know. But I will say we still, as of today, do not have, you can still see on the website, I believe, that it is not being maintained since April 30th of 2020. So we're almost to a year. We're getting close.
In our response, we pointed to meeting minutes from October 14, 2020, in which ordinance 2020-53 was voted down by the 4 council members at issue. Are you aware of that particular ordinance?
I am not. I don't have the exact language of that ordinance, but I would take it that what they put in there is is true. I will say this too. I had asked for these minutes before we filed the petition. we were not given the minutes until well into, we had asked for it in a sunshine law request. We were not given it by the council or by the law director until well into November. So, yeah, so I don't know exactly what went into that particular ordinance. We're not given copies of what the ordinance exactly says either ahead of time.
That particular exhibit that I mentioned is Exhibit 10 attached to the protesters' protest. Are you able to pull that up, Rachel? Or perhaps Mr. Patako might stipulate to the existence of the minutes which reflect that 2020-53, that ordinance was voted down, and that ordinance.
Do you know what page of the 153 pages of
Yes,
of exhibits?
Page 136.
Got it. Okay, and I'm sorry, which ordinance is it?
2020-53.
Ordinance to restore the contract with Stephanie Gandy to perform design and maintenance capabilities for the village website required to inform residents, the community, and ensure adequate public notice of meetings and declaring an emergency. And so,
See that there was a motion made to pass that ordinance by emergency.
right, so that was passed at that time with Adams, Miller, Brockwell, Nickerson, and Walker voting yes, Early and Wade voting no.
Look at the next sentence, beginning with the roll call vote. You see that?
Oh, that was I'm sorry, that was the suspension of rules, was the 5-2. And then the roll call vote failed 4-3. Shockingly, Brockwell, Miller, Wade, and Early voting no. And Nickerson, Walker, and Adams voting yes. I don't think that's in the best nature, best interest of the village.
And you don't prepare the language of the ordinance,
No.
correct? Someone else prepares that. And the language of the title of the ordinance above that is to perform design and maintenance capabilities for the village website required to inform residents, the community, and ensure adequate public notice of meetings.
Correct.
Correct? So, okay, so is anything in the language that you chose to employ in the petition itself for the grounds of recall with respect to the website, is any of that inaccurate in your opinion?
Not in my opinion.
Did you intend to, I'll ask the question in a better way. You intend to mislead the people you asked to sign that petition with respect?
Absolutely not. Of course not. And again, the language says that they voted against reestablishing the village website. The website provides information and public notice for council meetings. An inactive website potentially violates the Ohio Sunshine Law, which they have no way to put notice out. So most of the meetings they had in 2020 were actually invalid because they couldn't follow their own charter with regard to that.
All right. Well, we'll let others decide whether or not things were invalidated, but we're going to get just specifically with respect to the language in the petitions that you chose to employ. How about the master planning public meetings? Let's get to that paragraph, which is the next one. You allege that each of these 4 council members did not attend any master planning public meetings or educate themselves on the project. And that topic has been discussed at some length today. Can you inform us as to what you meant when you drafted that particular language?
Sure. What we meant was the specific master plan meetings. There were 3 of them in 2019. They invited the village. I don't think they, so that everyone, different neighbors could meet and we could decide, give them feedback about what they were suggesting. And then there were findings. But there were 3 meetings in 2019. There were sign-in sheets that I received for 2 of them, again, from the Sunshine Law. And I was at the first one. They were not there, these 4. I believe there were other council members, whether they were council members at the time or not, but that was what the village, residents wanted in the way of us. That was where the sidewalk information came out. That was where, just what to do with Eaton Collection, what to do with Village Square, now that Whole Foods isn't there, all of these different things, we were all getting together as a village to discuss with these specific people. And so for the recall for here, to say they didn't know the difference between those meetings and the planning and zoning final presentation is really silly. We all knew in the village that that was going on, and we were excited about it, and we had lots of people with lots of different opinions. So those were the specific 3 meetings run by the Master Planning Commission. And again, when we're writing, we're limited to 200 words. It's hard to say on this date, and this date, but not this date, and this date.
Let's
And
get to
never,
that. Rachel, let
yeah.
me ask you a question about that. You mentioned the two. Yes, sir.
Mr. Just, I mean, ask the questions and you can have Ms. Efron just answer them instead of kind of doing a dialogue here. Just
Yes,
ask
sir.
your questions, create the record, have her answer.
Thank you, Mr. Chair. I apologize. I just want to make sure that the record is complete enough. That's all. But I will ask this specific question. You mentioned a 200-word limit. Tell me where that comes from, if you know.
That comes from I believe it's the codified ordinances of Woodmere, but also the Ohio Revised Code.
That's actually, I'll correct you. It's in the charter, and the charter requires that statement for the grounds for recall to be made in 200 words or less.
Okay.
If you had more than 200 words, would you have the ability to create more than 200 words? Would you have changed your language?
Certainly. I mean, I'm a lawyer. I would certainly put like more information and more specifics, but we were limited to that. And we wanted the village residents to know as many things that this council we felt had done wrong. So we put that in there, and we were truthful at the time, and we're truthful now.
Thank you. Have you been involved in any public meetings since those master planning public meetings that we've discussed?
Yes, I have been.
Excuse me, in which any of these council members were criticized for not attending those earlier public meetings, or at least were challenged on that particular issue?
I don't believe that Council President Mitchell Early would allow for any challenges, but I'm not sure if there are residents. I mean, there's a lot of notes, and they do have open comments. So I'm sure that there were members that were critical of different parts of this, but I don't know specifically.
Do you remember any meetings at which council members explained that they didn't attend those first 3 public meetings hosted by the Planning Commission? Do you ever remember where there was a discussion on that particular point?
I don't recall it as I sit here today.
Okay, all right. My understanding, from my recollection of conversations, and I want to be certain that you can clarify this, so I'm attempting to refresh your recollection here. Were there not meetings, public meetings later at which council members said, I didn't attend the initial public meetings because of this, but I have been at other meetings where we discussed the master planning process?
Again, not that I recall. I don't know.
Okay, all right, that's fine. Thank you. Were you?
The next, can I clarify? Sure. I would just say that the next time I think we even heard about it in an open meeting, in a council meeting, was that they had like tossed out, like they didn't decide to follow it. So that was part of it, that they had voted, I believe, against it, but I don't, know all the ins and outs of the legislative stuff.
Okay. Well, you did write that they voted to table the discussion of that particular master planning document. Is that accurate?
That's correct.
Okay. And you also wrote about how the master plan process was made possible by a grant from Cuyahoga County, and you had concerns that the vote to table would affect future grants. Can you explain that a little bit?
Sure. I think whenever the county is giving a village money, or going through a process like that, for them to find out that we didn't do anything with it, or that, especially like where the sidewalks came out of that, and then we decided to turn down that $265,000 that the concern is that now maybe when we need to widen Chagrin Boulevard, they're going to be like, forget it, because they didn't, they don't want to move forward. Now, I don't know a lot about how city planning goes, but that was certainly a concern of members of the, of our committee.
Okay. Did you intend to mislead any of the signers of those petitions with respect to the master planning process and the council members' attendance at the public meetings?
No.
Let's turn to the chicken matter. And I don't mean to make light of it, but it is amazing to me that we're talking about the chicken matter right now. Do you have any question at all as to whether or not the village ordinances require a special permit for the raising of hens or chickens?
So my reading of this section, which was 505.13, states that it's illegal to have a list of chickens or a list of different farm animals. And then if you want to have them, you have to apply for a special permit. And then within that statute, once the person applies for the special permit, which the Achbens in this case did, then the council has a duty to go out and measure the lot and write a report about water and all these different things, which they did not. So to me, again, they were requiring the special permit, but again, we have another resident in the village who has a rooster, but he didn't have to get a special permit. So I felt that was improper.
Do you have any question though that the special permit is required?
No, I mentioned it. They required the special permit, and again, I felt that it was improper to have them do it when they didn't have the other village resident with poultry do it, and they made a distinction based on existing residents versus new residents. I felt that was improper.
Okay, so Mr. Patakos argued earlier that because the village ordinance requires a special permit for the raising of chickens, it is factually inaccurate that the council members acted improperly in requiring the new family to obtain the special permit. He's suggesting that the petition circulators didn't refuse to acknowledge the existence of that ordinance. You're not refusing to acknowledge the existence of that ordinance, correct?
No, of course not.
Okay, you knew that a special permit was required.
Right, but I just said our feeling at the time and in the council meetings was that it was improper to require one person to have it, but not another person.
Okay, and it was your understanding at the time that the earlier residents who were raising poultry did not have a special permit, or
current residents have poultry without a special permit. Other residents have these newer people needed the permit, and then they ended up getting rid of the chickens. But it was the constant language of new residents versus old residents that we have felt is inappropriate to be the determining factor.
Okay. You also wrote at the conclusion of your short statement for the grounds for recall that the council members, quote unquote, appear to have a personal agenda that does not align with the best interest of the community. Is that intended to be a statement of fact?
Well, it's certainly opinion, but it's based, again, I can't, because they will not provide, based on the sunshine laws, they will not provide their emails and text messages between each other. There's no way for us to know how many open meetings they have had together, but that is where the personal agenda language, my concern is that because they haven't provided that maybe, again, I don't know if they're, if they're hiding something, but it's opinion, of course, and it's, we're writing something persuasive to the voters. So, but everything in here was material.
All right, Mr. Butler, let me just answer the question, Ms. Efron. Mr. Butler, we're coming up about 50 minutes in your case in chief, so I'd ask you to start winding it up here so Mr. Patakis can have a chance to do some cross-examination. I think you've touched base on each one of the issues.
I have
in the
one.
petition.
Thank you, Mr. Chair. I have just one more question. As you were a circulator of these petitions.
Yes.
Did you make any statement to any prospective signer of the petitions as to what the petitions would accomplish?
Certainly, that was, people ask, why are you here? What is this about? And we let them read so yes.
Okay. Did you ever state that the petitions were circulated for a reason other than for the recall of those 4 council members?
Of course not.
Okay. Thank you. That's all I've got.
Thank you. Mr. Patakis, you could cross-examine Ms. Efron.
He's muted. muted.
Muted. You gotta unmute yourself, you're muted. Linda, thank you.
Sorry about that. Thank you. I have just a few questions. This should not take more than a few minutes.
Go ahead.
Thank you. Ms. Efron, have you reviewed my letter submitted to the Board of Elections? Are you familiar with that document?
Are you talking about the one from January 15th?
That's the one.
I do, I've reviewed it in, like, briefly.
Do you have it in front of you right now?
Yes.
Okay, I'd ask you to just keep it handy. And I just want to ask you a few questions about what your position is on certain facts at issue in this matter. The first being, do you dispute, and here I'm looking at numbered bullet point number 1 on the first page, toward the bottom of the first page of the letter. Do you dispute that my clients, the Woodmere council members that you are seeking to recall, who I will refer to as my clients throughout the rest of this examination, do you dispute that they attended the meetings identified in my letter as documented in Exhibit 3, Exhibit 4, Exhibit 5, Exhibit 6, and Exhibit 7?
I was not at those meetings to my knowledge, but as I look through your exhibits, August 7th, 2019, which is Exhibit 4, Exhibit 5, and Exhibit 6, I believe are all council meetings. And then you have the Board of Zoning meeting that was July 14th, 2020, but those were not the master planning meetings, and everyone who was involved in village, issues at that time knew that the master plan meeting was those meetings were happening, and that's separate.
I understand your position, and I don't really want to argue with you about that. I'm asking you a simple question. Do you dispute that my clients were at these 5 meetings? July 4th.
I cannot testify to that because I was not at those meetings. If your clients testify, that's on you. I can't testify as to that.
I'm just asking you if you have any reason to dispute that they were at those meetings.
I can't state it one way or another.
Okay. Thank you. My next question about that is, do you have any reason to dispute that the master plan was discussed at those meetings?
I wouldn't know.
Okay.
I'm sure, again, at a council meeting, if I only received the 2019 council minutes because they're not available. I only received them in or around 11, after we filed the petitions. So whatever they discussed in addition to other business, I have no dispute about that.
Okay, thank you. Now, moving on to the second bullet point on the next page, or the second numbered point, I simply want to ask you, and I believe you just testified to this, but I want you to confirm, you do not in fact dispute that Woodmere Code section 50513 states that no person shall maintain, keep, or stable swine, horses, mules, donkeys, cattle, goats, chickens, ducks, geese, or other fowl in the village, or any other animal other than a dog, a cat, or a domestic bird without first having obtained a special permit from council. You don't dispute that, correct?
That's not the entire reading of the charter section, but that's an accurate part of the first part.
Okay.
So, I mean, there's a whole process that they have to go through, like I said, and again, they did not require it for the gentleman who owns it's got to apply equally between with residents.
I'm not disputing that, nor am I asking you about it. I'm just simply asking you about this provision. Is there any other provision in the Woodmere Code that you are aware of that would state or otherwise provide that a Woodmere resident would somehow not need to obtain a special permit to maintain, keep, or stable any of the creatures listed in that statute?
I'm sorry. Could you repeat the question?
I can try. I might not get it exactly.
You're saying, do they need a special permit? I mean, for those animals?
Let me try again.
Okay.
Are you aware of any other provision in the Woodmere Code or in any other body of law that would suggest that a Woodmere resident would not need a special permit to maintain, keep, or stable any of those creatures identified in that statute.
I simply said in my statement that I felt that they acted improperly by requiring this. And my improperly, it pertains to the fact that they applied different standards to different residents. That's the acting improperly. Voters can go figure out if that's true or not true for them, but I'm saying that that was the acting improperly, and the fact that they did not go the next step in that statute, that charter provision, to say that they can, the council rather has to go out and get all this information in order to evaluate the special permit. So I'm just, there's nothing untruthful. There's nothing untrue in my statements.
I really wasn't asking about your opinion about the truth of your statement. I'm just asking you if you're aware of any requirement that would excuse a Woodmere resident from obtaining a special permit. And I understand your answer to be, no, you are not aware of any such requirement. Am I clear on that?
I can't take your answer, Mr. Patagos. I am saying that there's obviously someone in the village who has no special permit and has a chicken. So there's obviously some other way to do it. You have to ask your clients. I don't know.
Okay.
And that was brought up, and they were supposed to investigate it, and they didn't. So they acted improperly by requiring these people to have a special permit because they didn't follow their own rules.
Okay, but you didn't state that in your petition.
I stated in my petition that they acted improperly, and they did. I'm truthful then, I'm truthful now.
Okay. I understand that's your position. Thank you. I want you to look at page 136 of the exhibits again, and your attorney, Mr. Butler, was asking you about that specific ordinance number 2020-53.
Correct.
And you understand, you do not dispute that this was an ordinance to restore the contract with Stephanie Gandy, correct?
Correct.
Okay. I have no further questions for this witness. Thank you.
All right, thank you. Briefly, any redirect, Mr. Butler?
Mr. Chair, no redirect, but I regret that, and this is not a courtroom setting, I realize, so I would beg your indulgence. I didn't proffer any exhibits. We referred to 4 particular exhibits, one of which is just submitted for convenience, which is the charter.
Mr. Butler,
Village.
hold on, you're going to get that chance. So we're done. What exhibits would you like to proffer, Mr. Butler, for purposes of the record?
A, B, C, and D attached to our written materials, Mr. Chair.
That have been submitted to the board previously. Is there any objection, Mr. Patagos?
I have no objection. Thank you.
Okay, thank you. They're proffered. What we're going to do now at this point is I'm going to give each side 5 minutes, no more than 5 minutes for a closing argument. And then the board will take this matter under consideration. So, Mr. Patagos, you are the petitioner, the protester, excuse me. Why don't you start with the argument, sir?
Thank you. And, I would largely like to rest again on my opening argument, which I had more time to give, of course, and the facts that we set forth in our letter. I unfortunately have not had a chance to respond fully to these new cases that Mr. Butler introduced in this argument today. I haven't had a chance to sit down and read them and analyze them. I would ask for an opportunity to submit a brief letter tomorrow responding to these cases just on the legal position and the threshold question that I thought had been decided at the beginning of the hearing, but that Ms. Davis-Chappelle has raised and that Mr. Wondolowski has expressed concern over. There is certainly a legal answer to that question, and I would simply ask for 1 day to respond to these new legal arguments, some of which were just submitted late on Monday, and other new cases that that Mr. Butler cited today. But I can say right now in the rest of my 5 minutes that these cases, as I said, that Mr. Butler identified 2 cases, and I quote, as very clearly on point. These cases were decided in 1987 and 1993, respectively. The statute at primary issue here is 3599-14, which clearly prohibits certain acts concerning petitions. This statute was enacted in 1997 and amended in 2006. None of the cases that the circulators have cited addresses the specific provision of 3599-14, which is at issue here, which expressly prohibits making a false certification or statement concerning the petition or declaration. I think it is simply absurd that Mr. Butler would suggest that a statement that is contained in a petition for the purpose of influencing citizens to sign that petition is somehow not concerning the petition. I urge the board to reject that argument. I am sure the Supreme Court will. Now, I also want to emphasize regarding this White v. Board of Elections case that there's a big difference between whether there is good cause for removal of my clients or any elected official in Ohio and whether the petition contains any clearly false statements of fact. That's two different issues. We are not here to argue about whether there is good cause for my client's removal. We are simply here to point out that it is clearly a prohibited act under 3599-14 to make a false statement concerning a petition. And these petitions that have been circulated not only to demean my clients, but to eject them from their office contain demonstrably false statements. And that's it. I mean, from here, I would simply urge the board to please focus on the petitions themselves and the evidence that has been submitted that render those statements false. They needed to take 11 pages to try to explain why these simple statements were actually true or said something that they didn't really say. They're here to testify and argue that, oh, well, what I really meant was this. And, oh, what I really meant to say or what I really should have said was this. That doesn't matter. What matters is what the petitions actually say. And I simply don't think it can be emphasized enough. And I sort of feel like I'm in the twilight zone when I'm hearing people argue that demonstrably false statements intended to influence electors on a petition that needs to be certified by this board and the Secretary of State somehow should be ignored or somehow is not a serious matter. In fact, there is every reason to believe that 3599-14 was enacted in 97 and amended in 2006 precisely to eliminate any doubt about how important it is that petitions do not contain false and misleading statements of fact. So I suppose I will rest on the submissions. And again, I would just ask for the opportunity to submit a short letter addressing these baseless legal arguments that were just advanced today and Monday night. Thank you. Because the law is the law, I know you'll be advised by your counsel, Mr. Muss, and I would just like the opportunity to make our points here so that it may not be necessary for us to do that in the Supreme Court. Thank you. And I thank everyone for their time today.
Okay, right on time. Thank you, Mr. Patakis. Mr. Butler?
Thank you, Mr. Chair. Mr. Patakis did make a misstatement I want to correct. No one has made the allegation that it's okay for these circulators to make or that these circulators have made demonstrably false statements in their statement. In fact, Ms. Cab Efron's testimony demonstrates that there were no false statements intended or made, and that anything that might have to do with parsing language is either a statement of opinion or is subject to different interpretations by people in different settings and in different mindsets. That doesn't mean that anyone violated a criminal act in making false statements concerning petitions. So it's just not accurate to say that we are out there arguing that our false statements should be subject to no scrutiny. There are no false statements here. That's what we're arguing. But more importantly, there is that threshold issue, and we did put it in our brief, and so Mr. Patakis has had an opportunity to respond to it. And that is that the law in Ohio does not require or permit the board to consider the truth or veracity or accuracy of statements made in a recall petition that support the recall. There's just no requirement of the law. And as the chair indicated in these proceedings, that the board has to hear written protests and it has to consider those, but it can only invalidate petitions. It must otherwise accept all those petitions if they violate any section of the revised code, violate any requirement established by law, or violate chapter 3513 of the revised code or any other requirements established by law. That's 350139, and it's also agreed to by the Jameson Court, which I've cited earlier. There is no requirement in the law with respect to what petitioners must write in in recall petitions. There's just nothing out there for the board to hang its hat on. And the White Court in the 8th District did in fact agree with that. It didn't just say, hey, we're considering this purely under the charter. The White Court specifically said that those are political issues. Those statements made in recall petitions are political issues for the voters to decide. In that case, we didn't make it clear. The council members who were challenging those petitions said that they misstated whether or not the council members had a conflict of interest. In fact, they said that they believed the statement that they had a conflict of interest had no merit. That's in that particular case. So they disagreed with the statement. They thought it was factually inaccurate in the White case, that they had a conflict of interest, and that was placed in the recall petition itself. The White Court said it's okay for the Board of Elections to disregard that protest under those circumstances, because we're not in the business of determining for the voters whether or not they should recall a person based on the statement offered for recall in the petition itself. That is very clear in Langley as well. And in any of the cases that the protesters have cited where the courts have looked at petition language, those are in the context of referendums and zoning matters, which come with specific statutes that say the contents of those petitions must be accurate. In other words, the number of acres that are going to be rezoned has to be substantially accurate, right? There's no such statute in this particular case, which says the same thing with respect to recall. Not a one, and not a case, nor a Board of Elections has made a different determination. Under those circumstances, we believe the board, even though it has entertained this argument today and gotten into whether or not things are true or false or opinion or fact, can do nothing else but to deny the protest based on the fact that you are without authority to act here. And I say that respectfully.
Thank you, Mr. Butler.
Thank you, Mr. Chair.
Thank you, Mr. Butler. Thank you. We both 5 minutes. I'm going to open up to the board now to questions of either Mr. Patakis or Mr. Butler, or any motions for the board to consider.
I just want to, I appreciate counsel, the arguments that have been presented today. I appreciate the testimony given today and the time we took to kind of flesh out and drill down to the four factual assertions. I do think that we didn't have to get there. I'm glad that we did, though, as a practical matter, because the elucidation of the four factual assertions and the testimony given really suggests to me that each of those statements is pregnant with opinion and fact and meaning and intention that is broader than one could simply gleaned from the four statements by themselves. Ultimately, the assertions, whether they are characterized as opinion or facts or half truth or not complete truth or whatever, go to the question of whether or not the office holders, in the eyes of the voters, have done their jobs in the way that they are supposed to. And that's not for me to decide as a board member. I really am struggling. Some of the testimony seemed to me a little far afield to have to listen to, but I'm glad we did, because it just goes to my view that it's not for me to decide once a determination has been made by the clerk that the basic statutory requirements have been met, that the signatures are sufficient, that we as a board, I don't think we can move far beyond what that requirement is once we receive the petitions and they meet the basic statutory requirements. If we're going to start evaluating every ground for recall as stated in a petition or any ground stated in the documents beyond having met the threshold statutory requirements, I think it's a slippery slope, and I don't think that we are charged with doing it. I really think that's for the voters to decide. And I understand that the Supreme Court may weigh in because of the amendment that you've referenced, Mr. Patakas, that we don't have any recent case law perhaps that gives us a different path or different guidance. I just don't think that I am able to hang my hat on any legal precedent that suggests that I can second guess or that I can determine that, this 359914 is somehow a requirement established by law that would invalidate the petitions or obligate or require me to say that this shouldn't go on the ballot for the voters to decide. I really do think that is a question for the voters to decide. And so for that reason, I would, or for those reasons, I would move to deny the protests.
Okay, is there a second?
Second.
Second, Mr. Frost. Any other comments from the board members?
Yeah, I'll comment.
Mr. Frost.
I agreed with Mr. Wondolowski's motion earlier, the same motion that Ms. Chappelle just made. But I also agree with Ms. Chappelle that I'm glad we had the presentation of the cases and that we were able to hear the basis for the protest more fully that Mr. Patakas presented and that Mr. Butler responded to on behalf of their respective clients. Because as Ms. Chappelle said, I think it very clearly demonstrated why these are not issues for us to decide. The issues of truth of the fact stated or where fact and opinion, the line between fact and opinion. I do not think it is appropriate for someone to be able to make false statements in any electioneering matter. There are processes for us to handle this, but this protest here today, I do believe that we are limited to the specifics of the statute by which we are charged. I think that Mr. Butler's reliance upon the White case is well placed. I think that the Langley case, albeit an 11th district case, that it's expounding on and explaining the White case is illustrative and is persuasive and demonstrates that the Langley case is consistent with statewide jurisprudence. So I think that the citing of those cases, White and then Langley, going further and explaining the application of White more completely to our application of this case is well founded. So, again, I agreed with the motion originally made by Mr. Wondolowski that has now been re-put forth by Ms. Chappelle, and I do intend to support the motion to deny the protest.
Mr. Wondolowski?
I've said everything I need to say.
Terrific. I will rise and support too. First, as a matter of record, Mr. Patakas, I respectfully deny your motion for a continuance for an additional letter to address White and the others. At this point, and it's certainly something that you preserve the right to argue if you decide to appeal our administrative decision here today. There is certainly a presumption, as we're all aware, that the courts want ballots, issues on the ballot. That to prohibit people to get on the ballot, it's got to be an extraordinary reason to do that. I also believe that, well, we've decided, and I disagree with Mr. Butler, I agree with Mr. Patakis that this body has the right to hear this protest that was filed by Mr. Patakis and argued so eloquently on behalf of his clients. I also, in just my opinion, I think Ms. Chappelle may have commented, and I don't want to, that maybe 3599-14A7, I think Mr. Butler, who passionately argued on behalf of his clients, precludes us from going any further. I disagree with that. I do think we can take a look at that. I think Mr. Butler put on the record that no, his client anyways, Ms. Efron, when she testified, didn't make any misrepresentations as to, while circulating the ballot. So we can move on that. And I think 3501-39 gives us jurisdiction again to hear this matter, albeit a matter of first impression here too. So for those reasons, I am going to respectfully join in with Ms. Chappelle and Mr. Wondolowski and Mr. Frost in denying the protesters' protest here today. We have a record that's completed. We have a court reporter that's kept a record here. A transcription parties need to pursue. So all in favor of the motion to deny the protest signify by saying aye.
Aye. Aye.
Okay, motion passes unanimously. I want to again thank you both, Mr. Patakis and Mr. Butler, for being wonderful advocates for your clients. If you need anything, Ms. Linda Walker here can assist you, as well as Ms. Katie Simo of our office, for if you need any records or anything to proceed accordingly. Thank you very much. That'll conclude the hearing. We're going to go back into our regular business. Thank you.
Thank you.
Thank you.
Back into. Yeah, Mr. Butler, Mr. Patakis, was there anything you need to, procedural questions? I don't mean to cut you off. Is there any questions you have for the board or myself?
Mr. Chair, since you asked me first, no, the answer is I just want to thank you all for your time on this matter. I know it went longer than you had hoped. Thanks.
Okay. Mr. Patakis?
Similarly, no questions, and thank you. And I'll be in touch about ordering a transcript if we want to do that.
Okay, thank you both, gentlemen. You did a wonderful job on behalf of your clients. Okay, on to the next item of business, which would be to certify the February 23rd, 2020 Village of Woodmere recall election. I will move to do that. Second. All in favor, signify by saying aye.
Aye.
Aye. Ms. Chappelle?
Yes, I did say aye.
Oh, I'm sorry, we got a little delayed.
I know there's a delay.
Motion passes. On to the I'll move to approve the ballot order for the February 23rd, 2021 Village of Woodmere recall election. If there's a second. Second. Thank you. Any questions or comments? Hearing none, all those in favor signify by saying aye. Aye.
Aye. Aye.
Great. Motion passes unanimously. Thank you, Ms. Chappelle. Then I will move to allocate the voting booths for the February 23rd, 2021 Woodmere special recall election. Allocation quantities are based on social distancing and room size per polling locations. A total of 5 voting booths will be allocated, plus 2 DS200 precinct scanners and 1 ADA Automark voting unit and 3 elective poll books. If there's a second. Second. Thank you. Any question or comment? Hearing none, all those in favor signify by saying aye. Aye.
Aye.
Great, motion passes unanimously. I will move to approve and send the voter information guide for the February 3rd, 2021 Village of Woodmere recall election. If there's a second. Second. Thank you, Mr. Wondolowski. Any question or comment? Hearing none, those in favor signify by saying aye.
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 Terrific, motion passes unanimously. We're on to the personnel agenda. Mr. Pilati.
Today we have a few items on our personnel agenda, starting off with the first item being a reassignment of a vacant position that is currently an election official 1 in our registration department. It's a position that Chantil and I now for a little bit of time and in consultation with Betty Edwards do not need to fill operationally. So we are going to move this position to the Fiscal Services Department and post the position for hire. In Fiscal Services, our mail services functionality has been now for a few years handled by a full-time temporary employee. Prior to that, it was a permanent staff doing it. It just makes sense to have a permanent person overseeing the mail services of the agency, as well as the introduction of the Infor County computer system has created additional layers that are needed to process procurement and accounts payable. And this position would also be responsible for assisting with that. So that is just moving a vacant position to be better utilized within the agency. The second item is the request for the Family First Coronavirus Response Act. That was something that the federal government passed in 2020 to help with COVID relief. And this is a leave in which employees were granted 80 hours of time if they had a COVID specific instance they needed to deal with. So for example, if they needed to go for testing, they were not allowed back, or still are not allowed back into the workplace until they get a result. They would use this time to cover that absence, as well if they got COVID themselves, would utilize this time to cover their absence from the workplace. We are able to voluntarily extend this program, and we want to do that for the employees for the first quarter of 2021. We have not seen really, unfortunately, a decline in COVID at this point in time. Employees would not get a additional bank of time, whatever their unused bank of time that they had would carry over into 2021 for use. We have, I believe, 24 employees who so far have utilized this absence time. And so that's probably about a third of our workforce. And still, it seems like every week we have another employee, luckily not testing positive, but going out for testing because of exposure. So we would like to see that, unless, of course, the federal government passes something new that would supersede this, we would sunset that. And then the last thing on the personnel agenda deals with, we have just a handful. We have 4 employees who are exempt employees, part of the management team, who they accrue exchange time for overtime hours worked. That's straight rate, basically straight rate comp time for the most part. Because of the presidential election and the pandemic did create more work for us. We had record turnout in vote by mail, early in-person voting. We successfully executed our offsite collection box program. That required people to be here above and beyond that 140 hours. And they willingly, without any resistance, stepped up to the plate to do that. And so at this point, for that, we want to go back for those 4 employees and cash out their hours that are above the 140 to get them down to the maximum. 3 of these 4 employees also are almost at their vacation max, so there really is not a time for these individuals here to utilize that. This is something that the Center for Tech and Civic Life grant that we were awarded falls within the parameters of that. We did check with that.
Mr. Pilati, excuse me for interrupting. On something like this, I mean, I think we can go into executive session because it deals with the matters concerning the compensation of individuals. And so without getting too further, I'm going to make a motion to do that, but hold off on it because there may be some other matters we can discuss in public session and not keep people waiting here, okay?
Sure.
Does any board members object to that in that regard? Okay. So I'm going to save that and make my motion in a minute.
Sure.
Without getting, but is there any other agenda items for personnel? Do you have one more matter that you wanted to mention? Supervisors and ballot?
Yeah, so that's just something that's not on the personnel agenda, but something that Shane Peel and I had talked about to better operate within the ballot department. That is, we transferred the whole vote by mail, nursing home and jail voting process to that department. They did execute well. However, the manager and assistant manager were stretched awfully thin, and it just it opens up the agency to potentially getting errors in that area, and of course that's not our standard. We don't want to grow the size of that department, but they currently have 5 supervisors, and what we want to do is we believe that an additional assistant manager who has oversight specifically on the vote by mail, nursing home and jail voting process is a better utilization of our management team in that department. What we would want to do would be a limited internal posting available only to the 5 supervisors in that ballot department. If they're interested, they would apply. Chantel and I would interview them along with the manager and assistant manager. And the candidate who comes out or applicant that we feel is best suited for the position, we would come and request for that individual to be reclassified. So we would not be adding any positions to the department. We would be elevating one of the employees up to that higher level for those responsibilities that I expressed. So it would, again, it'd be a limited internal posting. And I wanted to put that out there. So, just so you would know.
See if we had any questions
Any
or
questions,
objections.
comments,
or-
objections to that. And then this way, if everything's okay, we would go ahead with the posting. And if you saw a application, you'd understand the basis for it.
Any questions for Mr. Pilati on those 3 agenda items he brought up?
No.
Okay, hearing none. I don't think there's a motion needs to take place, does it, on any of those 3? Well, I guess we do. Do we need to, I'll move to extend the Family's First Corona Relief Act, which expires in December 31st, 2020, and extend it to the first quarter of March 31st, 2021. There's a second. Thank you. Any question or comments? Hearing none, all those in favor signify by saying aye.
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 And I will also move to, thank you, Ms. Chappelle. I will also move to follow the recommendation to reassign the vacant election official position from Registration Department to the Fiscal Services Department. If there's a second. Second. Thank you, Mr. Wondolowski. Any question or comment? Hearing none, all those in favor signify by saying aye.
Aye.
Thank you, Ms. Chappelle. And I will move I will acknowledge that the management team, the director, deputy director, intend to move ahead with some reorganization in the ballot department, which doesn't require the hiring of any individuals, but just a reorganization. And I'll, at this point, at least move to authorize them to proceed with that reorganization effort. If there's a second? Second. Thank you. Any question or comment? Hearing none, all those in favor signify by saying aye. Aye.
Aye.
Terrific. And then I'm going to just save this motion. Thank you, Ms. Chappelle. For executive session, I want to go through, we have agency goals that are on new business and voting equipment, Mr. Pilati.
I'm going to quickly move through the agency goals. Chantel and I sat down and we came up with 6 goals that we want to work towards in 2021. Some of these things are items that have been in the works and progress, and other ones are new. We think that this is, with the 5 elections that we currently are aware of, and the potential or the likelihood of having special congressional elections in this county, we think that these six items are a robust list without us jeopardizing us effectively executing those elections. The first, and you heard me talk about this before, is actually implementing the new agency website. So it's not a refresh of the current site, but it's a new platform that's easier to navigate. It complies with ADA requirements. We are going to push the county to make sure we get this done. We hope to have this done within the first half of the year, but maybe potentially within the first quarter. So we're actively working to get that done. Next, and this is in no particular order. The next is developing a comprehensive PEO online training program. We had to do that in the fall of 2020, but really that was a reactive measure to COVID, and we were kind of thrown into it. Now, it worked, but it definitely can be better. So in 2021, we're going to work to really fully develop and make that a good tool. And insert more slides and animation into it instead of it just being a PowerPoint. What's new about this, though, is we also want to incorporate it into the new poll worker training. And our thought is, the concept is to provide the new workers with an online piece before they ever come to class. So we give them definitions, terms of what's a DS200, what's an auto mark, a provisional ballot, and also give them some non-process related information. So ethics policy, dress code, things like that. So this way, when they come to their in-person class as a new worker, one, they have an understanding of some of the terminology, so we can just kind of hit on a refresher and really focus on the concepts of executing the election, those core duties that they need to do. Plus, we think it'll make it a little bit less overwhelming for a new person coming in because they will have some kind of exposure to some of the terms and concepts. The next is updating our policy and procedures manual. The current edition was published in 2004. In the 10 plus years, there's been changes in employment law, and we don't have all those captured in our manual. And so we've tasked Lori with this, and she's been talking to some temporary employees. We're going to bring in a part-time temporary employee to help with this process, who kind of will be the scribe putting together the document, and also will be putting together the document that will accompany it, that will highlight the changes from the old manual to the new. We'll set up some focus groups with employees on certain topics to get their input, so we can have buy-in in a manual that is compliant with law, but also the employees think is fair. The next is, we kind of started with this today at the personnel agenda, but Chantel and I are going to continue to review the agency organizational structure. You know, when we first got our positions of director and deputy director, we had a small exodus of employees, and we've never really recovered from that because everything just kept moving along, as well as we've had natural attrition you would have in the agency with people either retiring or resigning. So we want to look at our current vacancies that we have and how can we best use these budgeted positions now. Adapting to the changes in our operations, trends in voting, as well as succession planning, and trying to see how do we best do that. And the goal is to live within the current vacancies that we have. We have 10 current vacancies, and it could be a combination of reassigning from one department to another, actually reclassifying the position, or a combination of both those things. So we want to get staffed up this year and shore up the agency. The next is staff development. You know, our staff are our most important resources. We have to invest in them. We want to improve their hard and soft skills. It's going to include training sessions, going to seminars, or other opportunities that present themselves where employees can grow. We already started to take advantage of this with last week. The OAEO presented its REO classes. With it being virtual, we encourage a lot of employees to take it. We don't know what the number is, but we did have several employees who signed up for at least one, if not up to all 4 classes available.
Tony trained one of those classes on voting equipment. Was a very good class.
Nervous to get the reviews. But so we want to do that, as well as Lori has been working on kind of talking to Chantel too on some software training for Excel, InDesign, and other things that we do to make sure that our employees have the tools they need to do their job. And the last goal that we have, again, this is something you've heard before, it's the new voting equipment acquisition. The pandemic pushed us off our schedule on this very important decision. You know, new voting equipment only happens once every 10 to 15 years, and you have to get it right. It is a massive undertaking, but this decision will be made in 2021. And with that, unless there's questions on the goal, that leads into Chantel giving an update on voting equipment acquisition.
So just to add, why don't you forward that to the board? Some of these, you know,
Sure.
aspirational goals for 2021. Chantel?
Yeah, I'm just going to quickly talk about some of the changes that we've talked about and brought to you before. I think that we started 2020 with the goal of being able to implement new voting equipment by the end of 2021 due to the pandemic and unknown elections that we will have of substantial size in this county that we're anticipating coming up. We think that it would be best for the agency to push the implementation of the new equipment to the 2022 primary election. We do want to move forward with the selection and all of the contract negotiations and things of that nature during this calendar year. We just didn't feel like we would be able to pay the adequate attention needed and necessary of implementing a new system. We would have, regardless of any system that we choose, we would have been running simultaneous systems. So the current ES&S system and then whatever the system that we chose for the new selection. So with that being said, we do have a security summit that is coming within the next few weeks. I believe it's February 5th. It's a Friday. And in the morning session, we will have a public session that's Starts at 10 a.m. and will be 20 minutes in length for each of the 3 returning vendors in the selection process. And then that afternoon, we'll host individual sessions with each of the companies that is not open to the public, so we can get into more of the details. We will be sending invitations out to those events soon, and if I believe Tony Hauger may have actually already have been sending those out this morning. So they will be video taped. That's not a thing anymore. They will be recorded. Sorry, my children often ask what taped means. They will be recorded, and so if you're unable to attend, we will be able to pass those along to you. But we would love to have your participation in those events.
And the public session will be virtual,
Yes.
so people can watch from wherever.
So unless there are any questions, that's all I have for now. We will be doing regular updates moving forward, starting with the February board meeting, and Calgary will start to be involved in those updates.
Any questions? Okay, hearing none. Anything else for new business? Do we have anybody on public comment? I know we thought maybe somebody was going to make a public comment.
Only the individual that the name that I provided to you, Chairman Hastings, Mr. Eugene Glenn. If you're on the line, please unmute yourself to address the board.
Mr. Glenn, are you online? Do we have a public comment session? Okay, hearing none, then we'll move on beyond that, and then I will make a motion to go into executive session to specifically discuss the compensation of individuals here at the Board of Elections. There's a second. Thank you. Mr. Frost?
Yes.
Mr. Wondolowski?
Yes.
Hastings is yes. Ms. Chappelle?
Yes.
Okay, we're going to go, and we'll call you on it, Joe.
Okay.
On your cell.
Okay, thank you.
Chairman Hastings, do we need to retain the court reporter?
No, the court reporter can be excused. Thank you.
Thank you.
Thank you. Have a good day.
Thank you.
Thank you.
Yeah.
Thanks, nice job.
No job, no problem.
Thanks, Mark.
That was good hearing. Thank you guys.
To the guy that's on
Yeah,
there.
thank you.
Tony, will we need Lori?
I would defer to the board members.
Sure.
I mean,
Yeah, we got questions. You there?
that was a long one.
That was a case of first impression. I
Yeah.
had something like that.
That's interesting.
Yeah. I credit Mr. Butler for finding an 83 case.
Yeah.
The closest thing you can find, and then the 90 whatever one.
Yeah.
They're about
other than sitting, they have to go.
I wanted to hear what you had to say, but
It wasn't that cool. It will wow you next time.
yeah.
So I think that, I don't think it's not precedent setting.
Yeah, well, we'll make it clear that that's the case. Okay. Okay, Ida Jo, you back online?
I am.
All right, Linda, can you hear us?
Yes, I can.
Okay, we're back on the record, then I will move to come out of executive session if there's a second.
Second.
Thank you, Mr. Frost.
Yes.
Mr. Wandelowski.
Yes.
Ms. Chappelle.
Yes.
Hastings, yes, we're out of executive session. I will move to bring four employees, Ms. Becky Brake, Betty Edwards, Peter James, and Kendra Susi, who are part of our management team and have accrued exchange time balances over 140 hours as defined in the Policies and Procedures Manual, and compensate them for that time that is accrued over 140 hours at their hourly rate, making it clear that is provided under 29 CFR 55326. This one-time overtime payment will not affect subsequent granting of exchange times in future work periods. If there's a second? Second. Thank you. Any questions or discussion about that? Hearing none, all those in favor signify by saying aye.
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 Great, thank you all. Is there anything else for the good of the order unless?
Motion to adjourn.
Thank you. Second, all in favor?
Aye.
All right, we're back in February.
Take care, everybody.
Bye.
Bye-bye.
Okay.
Everybody, thank you.
David, take care.